already costed more than 8 years. Item 44, condonation of delay.
What do you want? Delay should not be condoned. I mention kon mein korchanti.
Will fast delay.
Onno kam achi na. Apya kon? Yes.
Item 2 mara the death appearance case.
हाँ.
May it pray to be taken on Thursday. Today, tomorrow, I may be accommodated Thursday.
No, it was actually
Yes,
sent
my
to
lord,
Honorable
send
Chief
it to-
Justice. That whether
That's
it
why
would
some
be hard, but he has said no.
No, I have no. I will
So
abide by
again,
that.
you are to start because
Yes, my lord. That's why I'm some only 2 days accommodation. Thursday, I'll definitely. My lord.
we have two.
Another
virtually
case, item
part-hard
one is
matters.
there.
One is, I think, Devashish Sarangi was doing a matter
My lord.
that is part-hard, and Mr. Honda, he was also doing another death reference matter. So, Jugal Panda, that is perhaps item number 6. So,
It was extensively hard, but again, it has to start. My lord.
Huh.
And my lord may remember that it was sent for additional evidence.
yes, that has already come.
My lord.
And you must have received also the copy of that.
Copy I have not received. My lord.
Why don't you receive it?
I have not received. My lord.
That I think the
Additional evidence.
which was given in that case of their juvenile,
My lord.
that was you pay
My
for
lord,
the
my lord,
legal
that's right.
petition to be confronted.
My lord.
So it must have been confronted, and
It has
whatever
been confronted. It
it
is my lord. She has
necessary.
also.
You have already passed order to that effect.
That it is
Let
to
a
be
copy of the additional evidence of PW1 recorded as
I'll
per order
receive. I'll
dated-
receive in
So
course of
why
time.
do-
My lord.
because you are harping that the discrepancies are
Yeah,
there,
exactly,
that
exactly,
whatever it may be. So
Well.
take the copy,
Well.
they do Mr. Chand, है ना?
I'll take it.
ठीक.
Maybe
So all right,
Thursday I'll start one.
as such,
Would next will be holiday.
17th. So we are जो ये दीटा मैटर रे जोटांग मामे पार्ट हार्ड करिथिलु मिस्टर देवाशीष षडंगीकर गोटे मैटर आ गोटे मिस्टर गोल फंडांकर मैटर तांको टिके इन्फॉर्म करिवे आफ्टर ऑर्डर्स दोस टू मैटर्स विल बी फास्ट टेकन अप ओके या
Also,
हां ए जो मैटर उडाको ए मैटर टा ନାଇଁ ସେମାନଙ୍କୁ ଇଏ କରେଇଦିଅ ଆଗେ ଏଇଟାକୁ ଦେଇଦଉନ ମିଷ୍ଟର ଚାନ୍ଦଙ୍କର ଯୋଉ ମ୍ୟାଟରଟା
item 2 day.
ଅଛନ୍ତି କେତେ ନମ୍ବର ମ୍ୟାଟରଟା ଏଟା
2 I guess.
ଆଇଟମ ନମ୍ବର 2 ସେଇ ଗୋଟେ ମ୍ୟାଟରଟାକୁ ଆଗେ
ଅଛନ୍ତି କୋରାପୁଟ ଜେଲରେ।
କୋରାପୁଟ ଜେଲଟା ଲଗେଇଦିଅ
କିଏ ସାର୍କିଲ ଜେଲରେ କିଏ ଅଛନ୍ତି?
ନମସ୍କାର ସାର୍।
ଆପଣ କଣ ଅଛନ୍ତି?
ଆସିଷ୍ଟାଣ୍ଟ ଜେଲର
ଟିକେ କ୍ଲିୟର କରନ୍ତୁ।
ସାର୍ ଆସିଷ୍ଟାଣ୍ଟ ଜେଲର ସାର୍।
ହଁ ଆସିଷ୍ଟାଣ୍ଟ ଜେଲର। ବର୍ତ୍ତମାନ ଇଏ ୟାଙ୍କର ମୁଦାଲା ମାନଙ୍କର କନଭିକ୍ଟ ମାନଙ୍କର ସବୁ ଓକିଲ ବାବୁ ଅଛନ୍ତି ମାନସ କୁମାର ଚାନ୍ଦ ଆଉ ତାଙ୍କ ତରଫରୁ ଏଇ କେସରେ ମୋକଦ୍ଦମାଟି ଶୁଣାଣି ଆରମ୍ଭ ହବ ଗୁରୁବାର ଦିନ 18 ତାରିଖରୁ। ତାଙ୍କ କହିବା ଅନୁସାରେ 18 ତାରିଖରୁ ଏଇଟା ଆରମ୍ଭ ହବ ଶୁଣାଣି। ଠିକ ଅଛି?
ଅନ୍ୟମାନଙ୍କୁ ଇଣ୍ଟିମେସନ ଦେଇଦିଅ କେବଳ ଏଇ ଦିଟା ଥାଉ ଆଜି ପାଇଁ ତାଙ୍କୁ ରହିବା ଦରକାର ତମେ କାଲି ପାଇଁ କହିବନି କେବଳ ଆଜି ଗୋଟେ ପାଇଁ ଡିଲିଂ ହେଇଯାଉ ଆଜି କେବଳ ସେଇ ଦିଟା ମ୍ୟାଟର ରହିବ ବୁଝିଲ
Quickly list fresh admission item number 7.
May I please your lordship, on behalf of Mr. S.K.Sahoo Hon'Ble, And challenging the order of conviction and sentence passed by the London Second Additional Session Judge Bhubaneswar. The applicant prefers this appeal.
What
The
is your
applicant
good
shall not
name? What is your good name?
take Manoj Kumar Pani.
You are an associate of Mr. Sanjay Narayan Sahu.
Yes, ma'am.
Okay. How many years of practice you have?
2 weeks.
2 weeks. अच्छा 302 आईपीसी नुआ ये को सेक्शन है
103.
हाँ
103.
sure
Yes.
right hard admit for the trial court report Chief April behind
Item number 8.
iPhone ठीक है second additional session judge Bhubaneswar এটা হচ্ছে city case number 35/122 সেটা দেখুন item number 7
Just this number.
हाँ same तो अच्छा hard admit since trial court record has already been called for in JCRL number 76 of 2024. No further order is required to be passed. Henceforth, this matter shall be heard along with JCRL number 76 of 2024. Is a connected word to use करते हैं और साथ जहाँ पे कहेंगे तो हमको engage करते हैं as the advocate. Yes.
Item number 9.
Yes, Mr. Das.
Item number 9, Your Lordship, query whether the appellant is alive or not. I've sent a letter. I pray for next treatment.
That order was passed on 1/7/24,
Yes, Your Lordship.
and today we are on 15th, and you are unable to obtain instruction
We do
from
not
the
have-
concerned police station, that is Bhuban police station, whether a man is alive or dead.
Did not have the copy, madam. Last week we have uploaded and taken the copy and sent a letter. I pray next week.
No, why he has not said? We are keeping it tomorrow. Obtain the instruction.
It is Thursday, Your Lordship.
No, tomorrow. Otherwise, we'll call him by personal appearance. If he is not responding, we know what to
No,
do.
actually letter I have sent on Thursday itself.
Whatever it may be. ଗାଁଟାକୁ ଯିବେ ତା ଘରକୁ ସେ ବଞ୍ଚିଛି କି ମରିଛି ଏତିକି ବୁଝିବାକୁ ଆପଣ 15 ଦିନ ହେଇଗଲାଣି. Yes. Next.
Item number 10.
My plea, Your Lordship. Convicted under Section 302 IPC and sentenced to imprisonment for life, Your Lordship, and fine of rupees 1,000. In custody since, Your Lordship, 17/3/2010, Your Lordship.
No, filed an application for bail.
My lord. Earlier twice, he was released on interim bail for 1 month each, Your Lordship.
When?
And in time, he has surrendered, Your Lordship. My lord. once in in mis in miscase number 969 of 2013, in the year 2013 or 31st July 2013, granted interim bail for 1 month, and your lordship.
Just a minute. So what is your years of detention?
My lord, 17/3/2000 and more than
17th in 2010.
more than 14 years.
And you have been found guilty under section
302 IPC, your lordship.
What is the prosecution case? What you have done?
My lord, here in this case, sole eyewitness is the RPW9, your lordship. And as per informant in first information report, the deceased was
PW9 is the sole eyewitness.
sole
With
eyewitness.
the doctor who conducted
PW5. There are two cord injury at back of the head.
Trial court reporter. Iron patti is the weapon of offense.
My lord.
Backside head. And Dr. Tabat PW5. Go to 2 cm, 1 cm. Frontonasal junction. Lacerated on the which is small around the injury. Brain matter coming out from presenting. Cause of death as a result of hemorrhage and so matter. So are you sure that you have never been released on bail during pendency of the trial?
Yes, lordship.
Final counter. এই সাইডে কোন আসুনি এপট সাইডটা যেটা হ্যাঁ গণেশজি আচ্ছা হଉ ঠিক আছে ফাইনাল আনা ହେଲା ସୁକ ହଁ ସରେଣ୍ଡର ଇନ୍ କୋର୍ଟ ହେଲା 17/3/2010 ଠିକ ଅଛି ଦେନ୍ ଅର୍ଡର ସିଟ୍ କୁ ପଳେଇ ଯାଅ ଟ୍ରାଏଲ କୋର୍ଟ ଅର୍ଡର ସିଟ୍ ଟିକେ ଏତେ ଦରକାର ନାହିଁ accused no perhaps you are not correct he was on bail make a wrong statement in court. On the basis of your statement, we'll write that this much of the period is in judicial custody for quite some time. After the case was, even on the date of when it was first reached in the sessions court, at that time also you were on bail. And throughout the trial you were on bail because it is mentioned accused is present. Absent, so 317, all these things.
Sorry, lordship.
On bail on 7, 8, and 10 also you were on.
Statement କଣ ଏମିତି କହୁଛନ୍ତି ସବୁ ଆପଣ ମାନେ ଆମେ ଯଦି ଆପଣଙ୍କର କଥାକୁ ଏଇକା ଅର୍ଡରଟା ଲେଖିଥାନ୍ତୁ ସେ ବିଷୟରେ ଏବଂ ଆପଣ ଯୋଉ କହିଲେ 14 ବର୍ଷ ଧରି ଯେ ଇଏ ଥାନ୍ତା you produce the custody certificate. Number 1. Number 2, he was last time released on bail. Twice he has been released on bail. Whether there is any allegation of misutilization of liberty. Right. The learned counsel for the petitioner submitted that this court has granted interim bail to the petitioner twice. Once on, as per order dated 31/7/2013 and 4/2/2020. Initially, he was taken into custody on 17/3/2010 after he voluntarily surrendered in court. Stop. The case records indicates that the petitioner was on bail during trial. Let the Learned Counsel for the state produce the custody certificate of the petitioner from the concerned jail superintendent and also obtain specific instruction as to whether the petitioner misutilized his liberty in any manner while on interim bail granted by this court. Matter be listed on 29. This matter on 29 July 2024. Copy of the order be had.
Item number 11.
Lordship, my lord. In this case, Lordship, the appellant was convicted 302/201 IPC and sentenced to RI for life and 5,000 fine, my lord.
Please use the mic properly.
My lord, he is
You have been found guilty under section
302 and 201 Lordships. IPC.
and when you were taken into custody,
Custody, my lord, 2nd July 2012 Lordships.
2nd July 2012.
Yes.
Whether you were on bail during trial?
No, my lord.
Okay.
Date of the arrest.
And in this court, have you earlier your bail application has been rejected?
No, my lord.
Never rejected.
No.
Okay. Have you been granted interim bail?
No, no, my lord.
Okay. So if your submission is correct, then you have almost undergone more than 12 years of
My
sentence,
lord.
right? Okay. So what is the allegation against you?
Only, my lord, PW2 is the eyewitness.
PW2?
Yes.
Eyewitness?
Yes. And extrajudicial confession before the
extrajudicial confession is there. Before whom?
villagers, Lordship.
PW? One. What is the name of the deceased?
Deceased. 3.
deceased. Triple murder.
Triple murder.
Yes.
Sure.
Purna
Munda.
Munda alias Bayani.
Hmm.
Rajat alias Ruburu Munda.
So why you killed 3 persons?
My lord, prior to the occurrence, there is a quarrel between the deceased and the convict, and the deceased was assaulted by means of Omori, my lord. Out of anger, he is assaulted, my lord.
Including a child also.
My lord? Two child, my lord. One male and
What is your ground for granting bail in such type of cases? Triple murder, 2 children. The paperwork has been prepared, no? Has not been prepared. Add it after preparation, it will be added. Miss case number 18 of 2015. The Learned Counsel for the petitioner submits that the petitioner was taken into judicial custody since 2/7/2012, and as such he has remained in custody for more than 12 years. And since the paper book has not been prepared, there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned Counsel for the state, on the other hand, opposed the prayer for bail and submitted that it's a case of triple murder and 2 of the deceased are children. And one of the deceased was thrown into a well after commission of the murder by the appellant. And PW2 is an eyewitness to the occurrence, and the appellant has also made extrajudicial confession before PW1. After hearing the learned counsel for the respective parties, the nature and gravity of the accusation, the evidence available on record, while not inclining to release the petitioner on bail but taking into account his period of detention in judicial custody, we direct the registry to expedite the preparation of the paperwork, and thereafter the matter be added to the hearing list. Miss case number so and so, stay of realization of fine allowed. Yes.
Item number 12.
That last package pursuant to lawsuit direction, state has given me copy of the one copy of the antecedent. Of course, it is of 2022. Letter of 2022, in which it is mentioned that appellant number 1, Bella alias Vishwanath Behra, is involved in 2 cases. So, accordingly, Lordship has directed me to file an affidavit regarding the status of the case.
Just a minute.
I'm filing the affidavit, my lord. He is out of 2 cases, my lord. In 1 case, he is an
Please, wait. So, Mr. Tripathi,
Yes, my lord.
first we want to know about that appellant number 5, Subhran Sukumar Das alias Tony, whether he is alive or dead. What is your report? We asked you to obtain the report from the Superintendent Circle Jail, Chaudhar. That was the submission made by the Learned Council that he is dead. Have you received a copy of that order which was handed over?
No, my lord.
ये मना कला कि अपन को ना पाओ लिखा
I have not.
a free copy of the order be handed over to the Learned Council for the state for compliance. Open court re order ta pass hela.
Last time when the matter was taken.
1724 the order.
Yes, last occurrence.
In fact, he died in jail.
So, Mr. Panda, that information must come and
Custody certificate जरूरी है ना, custody certificate तो चाहिए.
what you have done after 17, Mr. Tripathi, you are asked to obtain apart from that death intimation which you are supposed to give, there are also direction that you are to obtain instruction about the criminal antecedents.
Yes, my lord.
In respect of appellants number 2 to 4, because you only obtain instruction in respect of appellant number 1 for which Mr. Jafrullah is appearing. All the orders are uploaded on the very day. It is dictated in open court. And in addition to that, there is a order that a free copy of the order is to be handed over to you.
से कॉपी टा भी 2022 ର ପୁରୁଣା ରିପୋର୍ଟ
No, that's we are Sapura matter.
Purana
like
report
that is Puranic.
ଖୋଜିଛୁ ତାର antecedent.
କଣ ଚାହୁଁଛନ୍ତି?
Next week, my lord, I will take
Next
it.
week.
Yes.
With due respect, all these information
If your lordship directs the jail authorities, they can bring it directly. Why
No.
should we rely upon the AG's office?
No, this criminal antecedent, the IIC may say that will not grant you further time. We are keeping
Yes,
it
my
on
lord, that's
22nd.
Lalabag.
ଏ ଯୋଉ
ଜେଲରୁ ସେ
ଆମର ସେ
ମରିଛି କି ନାହିଁ?
କପି ଗୁଡାକ ଦିଆ ହଉଛି ତ ତାଙ୍କୁ ହଁ? ଲେଖ। IN number 2284 of 23 and IN number 2462 of 23. Mr. Jafrullah, what you are filing today?
My lord, the criminal, they have shown me on 2 cases.
This
I'm giving the comprehensive affidavit.
The Learning Council, Mr.
My lord, antecedent has come. All 4 persons antecedent has come.
Then you supply it to the, let
Yes,
them
ma'am.
have their say.
Yes.
So the Learning Council who are appearing for appellants number 2 to 4, you supply them,
Yes, my lord.
okay? And file also for the court, right?
Yes, my lord.
Like Mr. Jafrullah, they can also file their, what about, in persons of the order dated 1/7/2024, S.K. Jafrullah, Land Council appearing for the appellant number 1 has filed a comprehensive affidavit of the wife of the appellant number 1 relating to his criminal antecedent after serving a copy of the same on the Land Council for the state. Copy State Council.
Yes, okay.
The comprehensive affidavit is taken on record. Stop. Land Council for the states also files the file करिवे तो आज ही से जो
हाँ सर sanction दो.
Land Council for the state also files the instruction received in respect of the criminal antecedents of appellants number 2 to 4, which are taken on record. Stop. Let the copy be supplied to the respective councils who are appearing for appellants number 2 to 4. Stop. The matter be Land Council, however, submits that the matter may be taken up next week in order to obtain a report from the Superintendent Circle Jail Chaudhar as to whether the appellant number 5, Subhranshu Kumar Das alias Tony, is dead or not. List this matter on 22nd July 2024. Stop. After receipt of the instruction relating to the criminal antecedent, the Land Council for the appellant is at liberty to file comprehensive affidavit relating to the status of those cases, serving the copy in advance on the Land Council for the state.
Already supplied.
My lord,
Criminal antecedent supplied.
नहीं कोर्ट को दिले जे तांको
अच्छा
रेस्पेक्टिव
बाहर कर देंगे सब सर.
दे दीजन
my lord, for 2 and 3 I am appearing, my lord.
अरे कॉपीटा पाइले ना नहीं
No,
अपन
no, I
ऐसे
have
मना
मोबाइल
को
मोबाइल
mobile.
व्हाट्सएप.
कौन से व्हाट्सएप फोन लिख देम ताजी देते तक
My appearance may be noted.
you are appearing for whom?
2 and 3.
All right, so also appears for appellant number 2 and 3. And Mr. Mahapatra, you are appearing for the informant. Mr. Sorochandra Mahapatra, land senior advocate, appearing for the informant. Mr. Panda, you are appearing for
Number 4.
Mr. Devasis Panda, land council. Land council appearing for appellant number 2. है 1 fine, Mr. Jafrullah, 2 and 3. है Then 4, then informant. And state council, Mr. Tripathi. Yes, next. It will come on 22nd of July 2024. Free copy of the order.
Let it be listed in that if commencing 22nd, but let it be taken up on the 23rd.
No, it will be listed in the week. This orders list is for entire week, not a particular day.
Item number 13.
Actually, we can take on next week. Then. What was the last order passed?
Last order matter.
Custody certificate. Previous names of other councils also will not be reflected. Okay. Submitted the petitioners are two ladies and they have remaining custody. Land states certificates of এটা কোন ହେଲା Mr.
custody certificate first day assume
No, he wants it next week. So not only custody certificate but also instruction about the criminal antecedent. Okay. Please see the order every day. We are uploading it by evening hour.
Yes, Lord.
And try to comply it. Does not look nice.
This week it was a problem, my lord. It was not showing. A week.
What is not showing?
A uploaded order would assume not so error ଦେଖଉଥିଲା a week ଟା particular ସବୁ କୋର୍ଟ ମାନେ ଯୋଉ ହାଇକୋର୍ଟ ୱେବସାଇଟ ରେ ହାଇକୋର୍ଟ ୱେବସାଇଟ ରେ ଦେଖଉଥିଲା
ବର୍ତ୍ତମାନ ଦେଖିଲେନ ନା ନାଇଁ?
ସେକ୍ୟୁରିଟି ପ୍ରୋବ୍ଲେମ ବଟ୍ ଏ କେସ୍ ମୁଁ ମାଗି ସାରିଲିଣି।
Okay, ठीक है. Yes, next. 22nd as well. Vice as paid for by the Land Council for the appellant list this matter on 22nd July 2024. The Land Council for the state of first submits that he has already sought for instruction relating to the custody certificate, so also the criminal antecedent in respect of the petitioners, and the matter will be taken up next week. Then 22nd. Yes.
Item number 13.
May I please? But there is a noting that appellant number 1 filed an application for interim bail. He died in the year 2020.
Who died?
See, appellant number 1. That would a puruna miscase ta aisi listing is.
Acha. All right. Let me
2009.
IA number 1905 of 2019. There is an application for interim bail of appellant number 1. Mr. Vishwajit Naik, Land Council, appearing for the.
Although I was not appearing, my lord, but earlier we were intimated to this honorable court and order has been passed to the defect. He died on 25/8/2020.
Acha, Land Council for the appellants submitted that appellant number 1, Lupo Naik, state. In view of such submission, IA stands disposed of. Now, what do you want?
My lord, so far as the other appellants are concerned, my lord, many persons have died, and your lordship, my lord, by
there are 5 appellants.
my lord, there are
nine.
nine numbers of appellant.
9 appellants.
My lord,
ଆଉ ବାକି appellant ରୁ ବି
ଆପଣ
death ହେଇଛନ୍ତି?
ଇଣ୍ଟରିମ୍ ଅର୍ଡର ରିଲିଜ କରିଥିଲେ 4 ମାସ ପାଇଁ କି ଆଜ୍ଞା ସେମାନେ 19 ତାରିଖ ଦିନ ସବୁ ସରେଣ୍ଡର କରିବେ ଏଇ 19/7 ରେ. So your lordship kindly take up this matter after 19th
No,
for
just
ye.
one is dead.
Mail.
No, appellant 2 is also dead.
Appellant 2 is dead.
Yes.
So, acha, appellant number 1 ର ଯୋଉ death ପାଇଁ intimation ଟା ଆପଣ ଆଣିଛନ୍ତି?
My lord,
ନା order pass ହେଇଯାଇଛି?
order earlier order was passed.
କାରଣ abated କରିବ ନା? କେବେ ହେଇଛି କହିପାରିବେ ତାର?
Five 8/2019.
5/8/2019.
Appellant number 2.
Appellant number 2 ପାଇଁ ହେଇଛି abated.
No, 5/8/2019 is appellant number 2. Yes, sir.
Two.
We are on appellant number 1.
appellant number 1 ଯଦି death ହେଇଥିବ ତାର confirmation ହେଲା ପରେ ତା case ଟା abate କରିବ ତା ପାଇଁ ସେଇ order ଟା pass ହେଇଛି ନା ନାହିଁ. In respect of appellant number 2 it has been passed. And এটা mention ହବ ମଧ୍ୟ ଏଥିରେ record ରେ.
Post title
First title ରେ mention ହବ. କାହିଁ ଲାଗି ନାହିଁ ତ ସେମିତି କିଛି order ପାଉନୁ ଆମେ. ଆପଣ ଆଗରୁ intimation ବି court କୁ ଦେଇଛନ୍ତି ବୋଲି କିଛି ନାହିଁ.
lordship can direct the statement of against.
No, that will obtain. You said that there is already an order. ସେଇଥିପାଇଁ ଆମେ ଖୋଜୁଛୁ ଯେ କୁଆଡେ ଗଲା ସେ order. Oh, I see. 19/2020 रे लिखा है. It is submitted by the London Council for the appellant that appellant number 1, Ruponaik, died in jail custody on so his obsequious ceremony will be performed for and so. Appellant number 7 being the son of so and so.
He died.
Okay.
7 died, 8 also.
8 died.
Okay.
8 weeks.
7 and 8 both died.
7 and 8 died.
Again.
A1, A7, A8. A2 तो अपने order टा ये ही. किंतु अपडेट में ये है नहीं. So Mr. Tripathi, instruction आणन्तु. ये जो A1, A7 और A8 में, है ना? लिखो. It is stated at the bar that appellant number 1, Rupon Naik, comma, appellant number 7, Punia alias Sagar Naik, and appellant number 8, Sujan Naik are dead. Let the London Council for the State obtain instruction in respect of such statement made through the inspector in charge of the respective police stations. Hala? And matter be listed upon gote saptah douchu apanku. So today is 15/29 hala? List this matter in the
Appellant 1, 7 and 8.
ଆପଣ ଅର୍ଡରଟା ଦେଇଦବୁ ଫେର. 1 ନମ୍ବର ହଉଛି ନୃପ ନାୟକ ଲେଖିଲେ ସେ ହଉଛି ବଣେଇ ପୋଲିସ ଷ୍ଟେସନର ହେଲା. 7 ନମ୍ବର ହଉଛି ପୁନିଆ ଆଲିଆ ସାଗର ନାୟକ ସେ ବି ବନାଇ ପୋଲିସ ଷ୍ଟେସନର. ଆଉ 8 ନମ୍ବର ଯିଏ ସୁଜନ ନାୟକ ଇ ବିଲଙ୍ଗସ ଟୁ 30 ସିମେଗୁଡା ଆଚ୍ଛା ଝାରଖଣ୍ଡର ଏଇଟା. ଆଚ୍ଛା. You obtain the instruction. Matter will be listed on 29 July 2020. अच्छा.
सिम देगा.
Next.
On 29 minute for hearing.
Huh?
On 29 for hearing.
29.
For hearing.
No, let it come first.
After
Because if that comes, then this criminal appeal will abate in respect of those appellants. So we'll proceed for the rest of the appellant. Who is dead? Now this 3 will be there. So now the remaining, I think remaining will be 5 number. Okay. We'll proceed on that.
Item number 15.
May plus. Last occasion, my lord, instruction regarding criminal antecedent was sought for.
Yes, Mr. Tripathi.
I prefer tomorrow.
Item number 16.
Directed to take instruction regarding the criminal antecedent and also custody certificate.
Last date or whatever. So what happened to that other case in which you are also an accused in another 302 case?
I have informed to the jail superintendent, but I have not get any information.
No, you see, your submission that you are in judicial custody since 15/9/2015
Yes, ma'am.
may not be correct because you are committing a 302 case on 23/2/2022. Maybe during that period, COVID period or something like that,
Yes, sir.
you have been released on bail or by this court.
Yes.
How did you commit the murder, another murder in 23/2/2022? That is the instruction given by the State Council.
I was trying to get the information, but he not inform me anything.
ଯାହା ପାଉଛନ୍ତି ସବମିଶନ କରିଦଉଛନ୍ତି ଆପଣ ମାନେ। ଆପଣ କହିଲେ ଜୁଡିସିଆଲ କଷ୍ଟଡି 2015 ରୁ ରହିଲାଣି। ସିଏ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣୁଛନ୍ତି ଆପଣ 2022 ରେ 23/2/2022 ରେ ଆଉ ଗୋଟେ 302 କେସ୍ ରେ ଇନଭଲ୍ଭ ହେଲେ। That means you are gone outside, committed the murder.
Parole period.
Parole period.
Probably. Yeah,
So
exactly.
if that is correct, then why you will be granted bail? If you are granted parole and you are committing another 302 in which charge sheet has also been submitted, that is the submission. Have you taken instruction about
No,
that?
my lord, I have not get any information.
Then, so what is the custody certificate?
Tomorrow I will get it.
We'll take up this matter next week. You also obtain instructions. କୋର୍ଟରେ ଯୋଉ ଅର୍ଡର ଗୁଡାକ ସବୁଦିନ ପାସ୍ ହଉଛି ତାକୁ କ୍ୟାରି ଆଉଟ୍ କରୁଛନ୍ତି ନା ଯାହା ଚାରିଟା ବେଳକୁ ବାନ୍ଧି ବୁନ୍ଧି ଦେଇ ଥୋଇ ଦେଇକିନି ପଳେଇ ଯାଉଛନ୍ତି ଘରକୁ।
Even I talked with him, he has sent a copy, but custody certificate ଖାଲି front letter ଟା ପଠେଇ ଦେଇଛି। Tomorrow I
Of this matter
will definitely
next week, as paid for by the Land Council for the
Okay.
states, also the Land Council for the appellate.
ଚିଠିଟା ପଠେଇଦେଲେ।
This
Custody
matter
certificate.
on 22nd July 2020.
Hey.
Yes.
ଦେଖିଲେ
Item number 17.
Kindly taken up tomorrow.
Item number 18.
Lordship, in item number 18, noting is there custody certificate, surrender certificate is not filed. I have the surrender certificate, but this is a not legible copy, my lord. Can it be posted next week so that I file the certified copy?
All right. The Learning
Land
Council
Council.
for the appellate seeks for an adjournment till next week to produce the certified copy of the surrender certificate. List this matter on 22nd July 2020.
Grateful.
Item number 19.
I'm for the intervener, my lord. That company, my lord, but
take your order sheet.
Intervener means informant.
yes, my lord. Informant, my lord. The murder has taken place in that Max Graphite company, my lord, where the HR manager was brutally killed.
Mr. Patel,
Sorry, my lord.
for whom you are appearing, whether it is for the informant or any of the victims.
No, my lord. For
Informant.
Yes, informant. Now, on behalf of the company, my lord.
Acha. So where is Mrs. Panda, Reboti Lata Panda?
15 but ତାକୁ fine କରିକି ଦବ ନା।
You have got the deposition copies with you, Mr. Tripathi?
ନାଇଁ deposition copy.
So we are passing it over. She may come maybe in other court. Yes.
Item number 20.
Suraj Mahanti. You are there, item 20.
In this case, I have filed bail for two appellants. Last occasion, custody certificate was called for.
What is this application for interim bail?
My lord,
There is an IA 867 of 2020. It's for interim bail. Are you pressing this application?
no, I am
for
not
this?
pressing that. I am
Acha,
not.
lekho. IA number 867 of 2020 is an application for interim bail filed by कहाँ पे फाइल इतना है
So, one by it.
867 का देखिए देवे कहाँ पे फाइल इतना filed by no, it is filed for appellant number 3 and 4. The Learning Council for the appellants doesn't want to place this IA according to IA terms dismissed. Then ଆଉ ଗୋଟେ ରହିଲା IN number 580 of 2023 is an application for bail of appellant number 3.
My lord,
So we sought for some instruction or what? Last date?
yes, that is custody certificate. During interim bail, whether he has misutilized his liberty or not.
Yes. What is the instruction?
I pray for Thursday, my lord.
Hmm?
I pray for Thursday. I talked with the IS, but he is in duty, my lord. So, Bahuda duty. So, I pray for Thursday.
Oh, then it let it come on
Custody
22nd.
certificate.
Next week, my lord.
Custody certificate. Custody certificate. ma'am.
That is there.
Here ABC, everything is clear.
Seal ଅଛି court.
Right. ପାସପୋର୍ଟ ଅଛି ବା ଥାଉ।
Nine months and 28 days. Correct, पाँच साल। So, Mr. Tripathi,
My lord.
he has produced, it was issued by Senior Superintendent, Circle Jail, Paramuku,
My lord.
and it is 9 years,
9
9 months, 28 days. This is for prisoner name is S. Dambadora. His appellant number
1, my lord.
S. Dambadora is appellant number. So this is no relevant for deciding this bail application of appellant number 3. The application has been filed IA number 580 by for appellant number 3, not for appellant number 1. Suppose. यार relevancy कौन है जो produce कले
Wrongly, it is the sorry man.
court seal है ना
Sorry.
चलो announcing as Sadasiva Dora appellant number 3. देखिए
Yes,
Appellant number 2 is appellant number 2 on the corruption.
Sorry.
bail
Sorry.
custody certificate bail move होउची वर्तमान for appellant number 3 S भगवती डोरा ଆଉ ଆପଣ appellant number 1 ଆଉ 2 ର କଣ produce କରୁଛନ୍ତି ମୁଁ ବୁଝି ପାରୁନି ଅଛି ନା ନାହିଁ ନାଇଁ ତ ସେ ମଗେଇବେ ସେଇଆ କୁହାଉଛି ଆଉ ଆଚ୍ଛା ଲେଖନ୍ତୁ learned counsel for the appellants produce the custody certificates of appellant number 1 ଏଇଟା କିଏ ସଦାଶିବ କିଏ ସଦାଶିବ କେତେ number appellant number 1 and 4 କରିଦେବେ ହଁ appellant number 1 and 4 which are taken on record learning IA number so and so ତାପରେ ଏଇଟା ଲେଖିବେ IA number so and so is an application for bail of appellant number 3 and counsel for the state submitted that as per the order dated 1/7/2024, he has already sought for the instruction relating to the custody period, and the matter may be taken up next week. Put up this matter. So also custody period as well as the conduct of the petitioner number 3 during the interim bail period. The matter will be taken up next week. Place this matter on 22nd July 2024. Yes.
Item 21.
Mr. Pradeep Kumar Pradhan. So
list लिखिए
Item 22.
to Mr. Jafrullah.
22 I click for tomorrow, and finding not yet given. Tomorrow elected.
We pass an order on 9/7 that since both of you said that you are not having the deposition copies of the witnesses, we ask the registry to supply the same. You have
They have
received.
supplied, we have received.
Mr. Tripathi,
My lord.
have you received the? We said that you
Today
supply
I
the
will collect it
collect the
tomorrow.
pen drive. You want it tomorrow?
My
Alright, Kali without accused.
Order 23.
Mr. Ajodhya Ranjan Das.
No instruction with liberty.
Yes, madam.
No instruction, Suman Kumar Naik, 23.
Suman Kumar Naik. Acha, this second one. Sanjay Naik fine. Just a minute. Second that you have kale. 288 টা. Show up and
Well, item of 23. The prisoner petition is there and a power and file.
No, we'll take up that first one. We are taking up now the 280 of 288 ଟାକୁ first ନଉଛୁ ସେ ଆରଟା ବାହାର କରନ୍ତୁ ୟା ନାଁ ହେଲା ସଞ୍ଜୟ ନାୟକ first ଟା ବାହାର either Sanjay Naik is an appellant in that CRLA or not. No. So how many persons face trial? Okay, 4. Sanjay Naik. Madam, what is your good name?
Snigdha Rani Naik.
Huh?
Snigdha Rani Naik.
You are an associate of Sumant Kumar Naik.
No, wife of Suman Kumar Naik.
So that is an associate. So, Snigdha Rani Naik, an associate of Mr. Sumant Kumar Naik, submits that they have no instruction in the matter. In view of the submission, let a report be called for. Let instruction be obtained from the appellant through the learned trial court as to a trial court can be yes also. Let instruction be obtained from the appellant to the concerned jail superintendent as to whether the appellant is ready and willing to engage any other counsel or a counsel from the High Court Legal Committee will be engaged for him. Free copy of the order be handed over to the learning counsel for the state. Mr. Item number 288 288 টা বার করলি জেল ডেটা ছিল
25 instruction को नीचे देखिए.
একটু দেবো ফুলবাণী So, Mr. Tripathi, Fulbani jail superintendent to या ପାଇଁ instruction ଟା ଆଣିବେ ସଞ୍ଜୟ ନାୟକ ପାଇଁ ସେ no instruction କରିଦେଲେଣି ତେଣୁ ସେ କାହାକୁ engage କରିବ ଯଦି କରିବ ନଚେତ legal ଏଠୁ ଦିଆଯିବ ହେଲା. Yes, what about the first one, CRLA number
306. So the prisoner petition is there, power and file.
So, prisoner's petition at flag B. राजीव कुमार मिश्र को वकालत प्रदान फाइल कर दी बीनामा बीनामाटा देखिले राजीव कुमार मिश्र. What do you want now?
Short deposition copy.
Not yet, sir. Probably he will serve.
The period the prisoner's petition at flag D. That is the first one. in such order, wherein a request has been made to engage Mr. Rajiv Bihari Misra as his advocate. Mr. Misra has already filed Vinama, which is accepted. The names of the earlier engaged counsel shall not be reflected in the cause list henceforth. Stop. After लिखिए IN number so and so. This is an application for bail. Learning counsel for the appellant submits that you will supply the deposition copies of the witnesses examined in the trial court.
If here's the copy, we'll collect it from.
अच्छा, all right, छठड़ा काटी दियो अपनी. The land council for the state submits that he is not having the copy of the deposition, and he may be permitted to collect the same through his pen drive from the court master. Let the same be supplied to the land council for the state in his pen drive. Put up this matter next week. You want all right, next 22nd of July 2020.
Item 24.
May I please your lordship? Last occasion, your lordship directed my learned friend to obtain the CA, and the matter may be listed with the along with criminal appeal number 105 of 2022.
9/7/2024, this matter was taken off, and the order is it was admitted, and then state council sought for time to obtain instruction about the criminal antecedent. That's all the order.
My
But do you want further?
My lord,
Okay, have you obtained instruction?
I prefer next. I tried to contact him, couldn't able to contact her.
And all right, next week, the land council for the state submits that he is yet to obtain instruction as per the order dated 9/7/2024. It like the IN number 927 of 2019. Put of this matter on 22nd July 2020. Yes.
my lord, my humble submission. Let my learned friend may be directed to obtain the last chance. The last chance.
So he is facing difficulty because of this Rath Yatra festival.
Indore is probably busy there.
All right.
My lord.
Item number 25.
Mr. Sahu.
Last time, lordship, for some instruction, lordships.
Huh?
Some instruction, lordships.
What instruction we call for?
Tomorrow, your lordship can.
What? Tomorrow. Okay.
Item number 26.
Item 26. May I praise the lordship?
Mr. Misra, you are for the
informant.
okay.
Last occasion, your lordship direct sought for certain instructions.
Let us see.
Custody certificate and
Just a minute. Let us see that. Sanjeev for Vandaland Council, Mr. Janmejay Kotka, Mr. H.S. Misra, seek some time to obtain instruction about the criminal antecedent, if any, against the petitioner. So also to obtain instruction about the custodial. Petitioner has served the bail order copies of the co-accused. So, Mr. Das, we passed the order on 1/7/2024 for obtaining instruction regarding criminal antecedents.
And also.
And number 2 is the custody certificate.
No.
So, have you obtained that?
No, I have not obtained. Let me tomorrow or day after tomorrow. I have already sent these letters, my lord.
Then let it come on 22nd. Yes, Mr.
Any other day other than 20, I am likely to remain absent on 22nd. Any other day?
What this person has been released.
I have a copy of any date other than 20.
All right. It will be in the weekly list, but it will be taken up on 23rd. Okay. The London Council for the State submits that as per the order dated 1/7/2024, he has already sought for instruction regarding the criminal antecedents, if any, against the petitioner. So also to obtain a custody certificate from the concerned jail superintendent, and the matter may be taken up next week. The Mr. H.S. Misra, London Council appearing for the informant, submits that the matter may not be taken up on 22nd of July 2024. In view of such submission, list this matter in the weekly list dated 22nd July 2024, indicating therein that the matter will be taken up on 23rd July 2024. The London Council for the State shall obtain instruction as per the order dated 1/7/2024 in the meantime. Yes. And this
10
matter,
years in
this
custody.
matter, are you not following?
Yes, ma'am.
Then this matter is to be listed along with CRLA number 649 of 2019. Yes.
Item number 27.
My pleasure, Lordships. And this matter may be passed over, my lord, on behalf of Mr. P.K.
What pass over? What order was passed last date? 1974. So on so appears through virtual High Court of Bhubaneswar. Now engaged as the Did you receive the documents?
Yes, my lord.
Okay. You have also received.
I received that deposition copy.
That is exactly. So all right, pass over.
Item number 28.
Under section 3, 190A and 302, conviction for life matter.
Wait. Yes, Mr. Tripathi, what do you say?
I have only received the IA. Appeal memo is not there.
Why?
Now I'll see. Not
Not the appeal memo and the deposition, judgment copy.
My lord, also I have a copy, so that now I solved the in course of court.
London Council for the appellant served the appeal memo into judgment on the London Council for the state today. Have you received the deposition copy?
No, in course of day,
The Land Council further submit that he will supply the deposition copies of the witnesses with the Land Council for the state during course of the day. Put up this matter on 22nd.
Sorry, my lord, I filed a miscase for interim bail, my lord. That copy also saw my lord as singer. His mother died, my lord.
Okay. সেটা উপরে লিখতে হবে। So IA number 1683 of 24. This is an application for interim bail on the ground of death of the mother.
My lord.
Let us see that. When your mother died?
My mother died is my lord.
3/7/24. So what is your instruction, Mr.?
I have not taken the instruction.
Today we are on, so that maybe that the obsequies must have been over by now.
My lord. They only custody in 9 years, so that your lordship.
No, that's a different matter. But for this particular purpose, it is ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଆଜି ବୋଧେ 13 ଦିନ ହୋଇଗଲାଣି।
Yes, my lord. But matter is not least, so my sorry, my lord, I cannot least this matter.
ବେଲ୍ ପାଇଁ ଆମେ କନସିଡର କରିବୁ, ବଟ୍ ଆପଣ ଯୋଉ ଇଣ୍ଟରିମ୍ ବେଲ୍ କଥା କହୁଛନ୍ତି ତ ମାଙ୍କର ଇଏ ପାଇଁ, ତ ସେ ପିରିୟଡ ତ ଓଭର ହେଇଗଲା।
Yes, my lord, yes.
So you not face this IA.
Yes, my lord.
ଦେଖନ୍ତୁ IA number 1683 of 24. This is an application for interim bail on the ground that the mother of the petitioner has expired. The Latin counsel for the petitioner submits that since the obsequious period is already over, he does not want to place this application. Accordingly, IA is disposed of. So you go
Let
to
him
the
solve the
deposition
deposition copy
office
and then
and we'll take up this matter on 22nd.
Yes.
Okay.
They, my lord, it's also allowed to 15 days or cases move in the custody, my lord, 9 years above.
We'll consider your bail application on 22nd.
Yes.
Let him, you have not supplied even the appeal memo.
I saw what not receive myself, but in the court, I
Yes,
think.
sir, all right. 22nd July 2024. Yes.
Item number 29.
My lord, in this case, the appellant is custody more than 9 years, my lord. The date of arrest is 4th June 2015.
4th June
2015.
2015. Just a minute.
The appellant is convicted under section 302.
How many appellants are there in this particular JCRLA?
One, my lord. Those two appellant number 2 is acquitted.
Appellant number 2 is acquitted. So accused number 2 is acquitted.
Yes, ma'am.
2 persons face trial.
Yes, 2%.
So one was found not guilty, right?
Yes.
He has been acquitted.
My lord.
You have also been you are also acquitted of the charge under 2015-34, right?
Yes, my lord.
And you have been found guilty under 498A and 302, right? And what sentence has been imposed on you?
Sentence, my lord, life, my lord.
Okay, 2 years, 5,000 for 498A. In default to undergo RI for 4 months, 1. Then imprisonment for life, fine of rupees 5,000. In default, so and so, 302. So, what is the name of the deceased?
Lavanya Dehuri.
Lavanya Dehuri. Your name is Jatra alias Jatra Goita. How you are related to the deceased?
Oh, husband and wife.
Okay, you are the husband. So, when your marriage was solemnized?
So, my lord, within 3 to 4 years.
3 to 4 years. What is the date of occurrence?
My date of occurrence is 2nd May 2015.
Your wife was staying with you when she died?
Yes.
Yes.
So,
Sorry, my 2nd June, sir. 2nd June 2015.
Okay. What is the cause of death?
Cause of this marriage, asphyxia, my lord.
Asphyxia as a result of?
The result of
Who is the doctor?
Yes.
PW9.
PW9 is the doctor.
PW9. External injuries are there, bruises, abrasions on different parts of the bodies, and there are ecchymosis marks over the trachea on the right side corresponding to external injury number 1. External injury number 1 hala bruise of size right side neck 3 inch below the right ear. Okay. Then
Cause of death.
Throttling achi, asphyxia due to throttling. So it appears that there may be some kind of either assault or resistance, and ultimately you succeeded in throttling the neck of your wife, and that is the cause of death as per the PM examination. So any issue out of the wedlock during?
No, my lord. This is the main cause, my lord. After marriage, though she is not able to give birth to a child, the quarrel was continuing in between them several times. And PW1
So
and
you
PW10.
decided to finish her and bring another lady.
No. But, this is the quarrel is in between for that reason. That is also taken in a chief and also cross examination. PW1 is mother, PW10 is the informant, and then other.
So just answer one thing. Your wife was with you
Yes.
and she died a homicidal death on account of throttling. What is your explanation?
Explanation, my lord, due to the torture of the family member, she was hanged in the nearby the side one a tree, my lord. That was explained by.
So
PW
that means after commission of murder, you tried to screen the offense, the evidence, and thereby you try to show that as if it's a case of suicide, and you hang the dead body somewhere else. But truth came by way of this postmortem report finding that it was not asphyxia as a result of suicidal hanging, but it is a case of manual throttling.
Well, PW5 stated that, that in page number 92, Santosh Buita, he stated that they found the dead body was hanging and they caught the cloth, then taken to the house of the
Mr. Counsel,
my lord.
ଜଣେ ଯଦି ସୁଇସାଇଡ୍ କରିଥାନ୍ତା ଏବଂ ligature use କରିକିନି ତାହେଲେ report would have been otherwise. At least ligature mark would have been found around the neck in an oblique manner. That is not there. Only the signs which are available around the neck is of the throttling. ତେଣୁ ସେ କଥା ଭୁଲି ଯାଆନ୍ତୁ.
No, just I'm one man said that this is I'm not.
One man said, but what is your explanation on the accused statement? You said that there was no quarrel at all.
No, there is, my lord, there is sufficient evidence the quarrel was continuing in between them.
But you denied?
No, I'm not.
See your question number 1.
3. Back to
64.
ମିଛ କଥା କଳି ହେଉନଥିଲା.
Hello, what I am submitting, my lord.
And third question is ମୁଁ ଘରେ ନଥିଲି.
Any other family members were there residing with both of you?
No, only my accused number 1, 2, the mother, and accused number 1 is the appellant and wife. 3 men was residing.
So she has been acquitted. That the other accused has been acquitted. Nothing was found against her. So you are the person, your wife has died, and after committing the murder, you hang her body from a tree to show that she has committed suicide. And that is how the others saw him hanging from that tree. But the post-mortem report indicates that it's not a case of suicidal hanging because there was no ligature mark around the neck. So and this case is also ready for hearing. Paper book has been prepared.
Yes, madam.
2019 matters. It can be added to the hearing list and we will hear the matter. Why bail will be granted to you.
Not any condition, any stringent condition. 9 years something.
In trial court, you are not on bail.
No, I'm not in bail.
And in this court also, you have never been granted interim bail.
No, my lord. This is my first application, my lord.
IA number so and so. This is an application for bail. And counsel for the petitioner submits that the petitioner is in judicial custody since 4/6/2015, and as such he has completed more than 9 years of substantive sentence. It is further argued that the petitioner is the husband of the deceased Lavanya Dehuri, and their marriage was solemnized 3 to 4 years prior to the date of occurrence, and the occurrence in question took place on 2/6/2015. The Land Council submitted that the mother of the petitioner, uh, namely Tulasa
Tulsa.
Boito, faced trial along with the petitioner, but she has been acquitted of all the charges. And the evidence on record indicates that the dead body of the deceased was found hanging from a tree, and therefore it is a case of suicide, and therefore the bail application may be favorably considered. Land Council for the state, on the other hand, opposed the prayer for bail and praised the evidence of the doctor PW9 who conducted post-mortem examination and opined and noticed injuries on different parts of the body and opined the cause of death was asphyxia on account of throttling. It is argued that since the petitioner and the deceased were staying together and the deceased met with a homicidal death, and the appellant has not offered any explanation in his accused statement as to how the deceased died, the Lennon trial bail should not be granted to the petitioner. Considering he further submit that the paperwork has already been prepared and the matter can be heard at an earliest. Considering the submission made by the Learning Council for the respective parties, the nature and gravity of the accusation, particularly the evidence of the doctor PW9, we are not inclined to release the petitioner on bail. Accordingly, bail application stands rejected. However, since the paperwork has already been prepared and the petitioner is in judicial custody for more than 9 years, the matter may be added to the hearing list in the week commencing from 29th July 2024. Get ready for hearing.
Yes, my lord.
Item number 30.
05.
Item 30 kindly taken up day after tomorrow. The file is missing somewhere.
At the time of occurrence, the appellant was minor. At the time of judgment, he also minor. But the Law and Trial Court treated as a major and a convicted life. I filed IA and also filed citation of the Supreme Court. My lord, at the time of PW3, my lord, is minor witnesses. PW3.
No, what is your interim application?
My lord?
What interim application you filed?
You filed at the time of occurrence, he was minor. He was minor. At the time of judgment,
Treated as juvenile.
juvenile, my lord. I have also filed the citation of the, and
No,
I
what is
filed
that IA number?
I number 27888.
Have you, for that, you have annexed one document that is your HSC or school transfer certificate?
Yes, my lord. I have also filed
Have you
the,
served a copy of this IA on the London State Council?
yes, my lord.
So have you filed any objection to that?
File is missing somewhere. Let it come some other time.
Because the date of birth, as per the um,
School certificate.
school's transfer certificate, as it appears, date of birth is 3/8/1999, and this occurrence took place when this occurrence took place.
7/12/2014.
14 ହେଲା ହଉଛି 15 ବର୍ଷ ପାଖାପାଖି ହଉଛି।
My lord. At the time of occurrence, the appellant was only 15 years old.
No, it's all right. These matters are required to be inquired into. That decision shows that it may be sent to the concerned court to hold an inquiry and submit a report. So, but for that, you are to file your objection, if any. Okay.
Last chance, this court already direct to the
When?
State Council file the objection
କେବେ?
and verify approval date.
Just a minute, let us see.
Objection କରିବା ପାଇଁ certify verify କରିବା ପାଇଁ
No. Certify verify ସେ ତ ଆସିବେ, ସେ ଡକେଇବେ, ସେ ଇନକ୍ୱାରି ହେଲେ ସେ ହେଡମାଷ୍ଟର କରିକି ଆଉ ଆଣିଯିବେ, ଓରିଜିନାଲ ରେକର୍ଡ ଦେଖାହବ, ସେ ସବୁ ହବ ନା। ଆଉ ଆପଣଙ୍କର ସାର୍ଟିଫିକେଟ ଟା ବର୍ତ୍ତମାନ ଜେନୁଇନ କି ନାହିଁ, ତା ପାଇଁ ଏଭିଡେନ୍ସ ଆଡ୍ୟୁସ୍ଡ ହବ। ତା ବେସିସ ରେ ଆପଣ ଯଦି ଆଉ କିଛି ଏଭିଡେନ୍ସ ଦବାକୁ ଚାହିଁବେ ଦେବେ, ତାପରେ ଇନକ୍ୱାରି ରିପୋର୍ଟ ଟା ହେଲେ, ଜୁବେନାଇଲ ହେଲେ ତାପରେ ଅଲଗା କଥା।
ମୋର କହିବା କଥା ଆଜ୍ଞା, ଯେ ଯୋଉ ସାର୍ଟିଫିକେଟ ମୁଁ ଫାଇଲ କରିଛି ସେଟା ଟ୍ରୁ ଅର ଫଲ୍ସ ସେଟା ଇନକ୍ୱାରି କରାଯାଉ, ମୁଁ ମନା କରୁନି, କିନ୍ତୁ ବର୍ତ୍ତମାନ ସେ ଆଜ୍ଞା ଇଣ୍ଟରିମ୍ ବେଲରେ ଆଟଲିଷ୍ଟ ଯାଉ 10 years already complete. Juvenile treat କରି juvenile treat ହେଇନି, ସେ major treat
Not
କରି
having that particular IA copy, and you said that on the last date some order was passed. We are not finding that any such order was passed.
My lord, this honorable court,
IA number
Justice
is
C.R. Justice is
just
this,
IA number is 2788, right?
my lord,
2788 ଉପରେ କୌଣସି order pass ହିଁ ହେଇନି।
ପୂର୍ବ ଡେଟ୍ ରେ ଆଜ୍ଞା ହେଇଥିଲା। Justice Das was present before this court.
Take down. This is IA number. ସେଟା ବାହାର କରନ୍ତୁ, IA ଯୋଉଟା 27 କେତେ ହଁ, IA number 2788 of 2023, sorry. IA number 2788 of 2023. There is an application filed by the petitioner Giotto alias Sanatan Hissa for setting aside the impugned judgment and order of conviction, mainly on the ground that the petitioner was a juvenile as on the date of occurrence. In support of such stand taken, the London Council for the petitioner has annexed the copy of the school transfer certificate and Aadhaar card of the petitioner to the interim application as Annexure 1 series. And he has also relied upon the decision of the Honorable Supreme Court in the case of Vijay Singh versus State of Delhi, reported in 2012-53 OCR bracket SC 592. The London Council for the state submits that he is not having the copy of the interim application. Yeah, the submission.
I also
copy nahi tho? let the learned counsel for the petitioner supply the copy of the interim application along with all the annexures and the citation.
Evidence annexure ସବୁ ଆଜ୍ଞା ଫାଇଲ ଦେଇ ଦେଇଛି ଆଜ୍ଞା ମୋ ପାଖରେ ଅଛି ସ୍ଲିପ୍ ଆଜ୍ଞା ଅଛି
କଣ
ଅଲରେଡି ଫାଇଲ କରିଦେଇଛି
ଆଉ
ଆଉ
ଥରେ
ଗୋଟେ
ଦେଲେ
ଦେଇଦେବ
ହବନି
କଣ?
କାରଣ ନାହିଁ
ଆଜ୍ଞା 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 ଠିକ ଅଛି
foot of this matter on 29th of July 2024. Objection, if any, to the interim application be filed in the meantime, serving the copy of the same on the learned counsel for the petitioner. Yes.
Item number 31.
May I please? The petitioner is taken to custody on
Just,
20.
just a minute. Prisoner's petition at flag E for engagement of so and so filed Vinama or
That name error is there.
हाँ
Sujal Kumar Kesari Singh है ये सर स्वाधीन केसरी सिंह वकालतनामा फाइल हुए स्वाधीन केसरी सिंह
देखिए Vinama prisoner's petition टा से लिखी छी
in the prisoner's petition the phone number of the counsel is correct but
अच्छा
they
ओके ओके Vinama अपन फाइल कर दीजिए तो
my lord
Vinama टा देखिए मैं आधे आसिन कर दी हाँ ठीक है ओके लिखी दिया तो आइटम नंबर 31 peruse the prisoner's petition at flag E for engagement of से लिखी जी साजियल की
illiteracy
साजियल
that
किशोर
may be ignored
केशरी सिंह Mr. Swadhin Kesari Singh and his associates have filed Vinama and submits that he has given a phone number.
my lord
देखिए से phone number टा prisoner's petition
probably in the prison petition there is a number of
नहीं तो
counsel
कीजिए phone number कीजिए नहीं
because he contacted Mr. Singh
okay submits that the petitioner intend to engage Mr. Swadhin Kesari Singh but inadvertently the name has been wrongly mentioned as Sajal Kishore Singh and therefore the Bhinama filed by Mr. Swadhin Kumar Kesari Singh and his associates for the appellant be accepted. The Bhinama is accepted. The name of the earlier engaged counsel, Mr. Rasmi Ranjan Mishra, shall not be reflected in the cause list henceforth. What do you want now?
my lord a bail application is
You have filed the bail
my
application.
lord
IA number 1728 of 24. Yes, just a minute. How many appellants are there in this criminal
the
appeal?
sole appellant my lord
Sole
other appellants are acquitted or disposed of on 1st of November 2017
Just,
that is criminal appeal number 191 of 2003 and the present appellant is in custody more than 16 years
please have patience. The judgment indicates that it is only one accused who
My lord.
face trial. To hurry the question of other accused persons.
my lord in that judgment kindly have a glance to the page number 11 running page judgment page number 3 at para Roman 2i
No, the co-accused persons faced
trial and convicted they preferred an appeal that is 191 of
that is a separate trial.
separate.
Oh, that you said.
The present appellant taken to custody on 29th of May 2008.
Acha.
Since then, he is in custody.
And what about those persons who are found
judgment?
guilty?
I am.
You are not aware. All right, just let us go by one way. Your name is Suputa alias Ashok Jena. What is the custody date you said?
29/5/2008.
2008. And deceased is one Haramani Behera.
My lord.
So case under section 302.
My lord.
So eyewitness is there.
Yes,
my
lord.
Who is
The informant himself is eyewitness.
eyewitness
And
is
one of
PW,
the eyewitness is not a prosecution witness.
PW4 and 5.
PW4 and 5. So what they have stated, how the occurrence took place, and what is the role attributed against this present appellant.
Married. I know the accused PW4.
Yes.
I know the accused standing in the dock. I am the informant in this case. The occurrence in the case took place on 30/5/2000. Deceased Haramani was my sister-in-law, Baujo. Myself, deceased, and my daughter were standing near our cow shed on that day. At about 8 p.m., accused came in an auto rickshaw and got down from the auto rickshaw with a sword. 3 to 4 other were there with accused. Then all the person assaulted deceased with sword. I concealed myself along with my daughter in nearby fence. Those person went back in very auto rickshaw. I reported that.
That is also the evidence of PW5.
Yes, my lord.
And who is the doctor who conducted PM?
My lord, the cross examination is very
कौन
important.
कौन बाहर କରିଛନ୍ତି କିଛି?
Around my cow shed, I had given fence. The said cow shed situated 20 cubits away from the ready of the tank. My cow shed is the 40 cubits away from the.
No, you are about that visibility factor. You are arguing on visibility.
It was stated in the previous deposition in 191, the ST number 31. It is suggestion is there. Some suggestion given. It is not a fact that earlier I have stated against Dilip for assaulting. This is with sword causing injury in her head. It is not a fact that I have deposed against 2 other without naming anybody. Some discrepancy is there, madam, with that deposition. Otherwise, all the witnesses are hostile.
Just a minute. So you mean to say that in connection with this present case, earlier some of the co-accused persons faced trial in ST case number 31 of 2001, right? And there this particular witness was examined. He stated in a different manner. So once you suggested him that you have stated like this in the earlier case, in the same case of in respect of the other co-accused persons, so previous statement of confront कर ଦେଇଛନ୍ତି ତାକୁ ପ୍ରମାଣ କରେଇଲେ ତାକୁ certified copy ଆଣିକିନି ଦେଖେଇବା ପାଇଁ.
I have received that brief from Mr. Singh yesterday.
Then how can it be proved? ସେ ତ ମନା କଲା ନା. ଆପଣ ଯୋଉ କେସଟା ଆପଣ କହୁଛନ୍ତି ST କେସ୍ ନମ୍ବର 31/2001 ରେ
he has taken the name of one Dilip.
ଆରେ ବାବା ସେଇ ଯୋଉ ସାକ୍ଷୀର ଯୋଉ ଜମାନମୁଦି ତାର ଏଭିଡେନ୍ସ କପିଟା ଆର ଯୋଉ କେସ ର ସେଟା କୋର୍ଟ କେମିତି ଭେରିଫାଏ କରିବ? ଆପଣ ସଜେସନ ଦେଲେ, ସିଏ ହଁ ମାରିଥିଲେ ଅଲଗା କଥା, ସିଏ ତ ମନା କଲା, ନଟ୍ ଏ ଫ୍ୟାକ୍ଟ କହିଲା। ତେଣୁ ଆପଣଙ୍କର ହଁ, you have to examine whether that evidence
along with that appeal, the case may be listed next.
in the earlier sessions trial, whether it has been proved in accordance with law or not. ହେଲା ତାହେଲେ we can look into it that this is the exhibit, whether this ଆପଣଙ୍କୁ କେବଳ implicate କରୁଛି first time এই case
other than the present witness, all the witnesses declared hostile.
So verified
yes,
whether that
and the case may be taken up along with that appeal. 191 of 2003.
No, you see,
that
appeal maybe that they are the co-accused persons, okay, but the evidence might be different. This here this PW, this particular witness has been examined as PW4, In that case, she might be examined as PW1 or
different,
2,
yes,
and her evidence might be also vary because at a different point of time.
my lord.
So it is to be, if in one deposition would have been there, and the judgment, common judgment is there, and number of appeals filed, then that can be tagged together. But if different point of time they have faced trial,
With due apology, for the convenience of this honorable court, I am praying for that 191. Otherwise, I will.
it can be hard separately. We can produce the deposition copy, whatever it may be. It cannot be hard because it's not
No,
a
no, that
covered
cannot be hard, but only for the limited purpose.
right, because some of the witnesses examined in that
That
case might not have been examined also in this case. Who
Yes.
knows? ହେଲା ସେଥିରେ ଯୋଉ ସବୁତକ ସାକ୍ଷୀ ଏକ୍ସାମିନ ହେଇଛନ୍ତି ଆଦିରୁ ହୁଏତ କିଛି ସାକ୍ଷୀ ଏକ୍ସାମିନ ହେଇନଥିବେ, ତାଙ୍କୁ ୱିଟନେସ୍ ନମ୍ବର ବି ଅଲଗା ଥିବ,
No, no.
କ୍ରସ୍ ଏକ୍ସାମିନେସନ ବି ଅଲଗା ଥିବ।
No, so far as the present witness, the informant is concerned.
ଆରେ ଇନଫର୍ମାଣ୍ଟ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ତାର ଯଦି ଆପଣ ପ୍ରମାଣ କରିନାହାନ୍ତି, ଯୋଉ ଏଇ ଆପଣ ଖାଲି ପଚାରିଦେଲେ ଲେଟ୍ ଅସ୍ ସେ ଆପଣ ପ୍ରମାଣ କରିନାହାନ୍ତି ସେଇ ଯୋଉ ଡିପୋଜିସନ କପି, ତାପରେ ଆପଣଙ୍କୁ କଣ କରିବାକୁ ପଡିବ, ଇଟ୍ ଇଜ ଅପ୍ ଟୁ ୟୁ। What recourse is available in such a case, that depends upon what petition you are to file,
Yes,
what
my lord.
steps you are to do.
For
So
that
that
reason,
is the thing. But first of all, verify
yes,
from
my
the
lord.
list of exhibits whether the deposition copy of that particular witness in the earlier sessions trial
My lord.
has been filed and marked as an exhibit or not. Okay, unless you exhibit that document, we cannot look into it, even if you produce it before us,
My
right?
My lord.
And if it has not been done, then of course in law there are recourse available to you. You are to take it in accordance with law. All right.
My lord.
So go through it and you want it next week verified.
Any day, your lordship's convenience.
Right. After passing that order, the Learned Counsel for the petitioner, IA number one, place the evidence of PW4, ତା ନାଁଟା ଲେଖିଦେବେ କଣ ଗୋଟେ ଲେଖା ହେଇଛି, ସୁରେନ୍ଦ୍ର ବେହେରା, and referring to the cross examination stated that PW4 was earlier examined in connection with this case in ST case number 31 of 2001, and is stated in a different manner than what he deposed as PW4. However, when a query is made by this court as to whether the earlier deposition of PW4 in ST case number so and so has been proved in this case in accordance with law or not, he seeks some time to verify such aspect. Put up this matter next week, 22nd. Yes.
Item number 32.
May I please, my lord, on behalf of Mr. Rajiv Kumar Mohanto, kindly next week.
What is your good name?
Debraj Barik.
Debraj Barik.
Yes,
Mr.
my lord.
Debraj Barik, Learned Counsel, appearing on behalf of Mr. Rajiv Kumar Mohanto, 6 for an adjournment till next week. Put up this matter, we commencing from 22nd July 2024 with JCRLA number 25 of 2018.
Oh, bless, my lord.
Item number 33.
May I please, your lord.
JCRLA 4 of 2020. Single appellant. 302 life imprisonment.
Yes.
And you are in custody since
4th October 2016.
2015.
16.
16. What is the name of the deceased?
Pradeep alias Deepu.
Pradeep alias Deepu.
Yes, Pradeep Kullu alias Deep.
अच्छा,
Pradeep
Pradeep
Kullu.
Kullu, the Purana alias Deepu, DIPU. Okay,
Yes,
date of occurrence
3rd October 2016.
3rd October 2016.
Yes, my lord.
15 or 16?
16.
Eyewitnesses are there.
One eyewitness, PW3.
PW3 is the eyewitness. And who is the doctor?
PW8.
Yes.
PW8 PM doctor. Let us see the evidence of PW3. Earlier, your bail application has not been rejected on merit.
My lord, I have no
You
issues
do
because
not
I have
know.
entered application 19.
এটিকে যে সিআরএল দেখিয়ে দেবে?
And I think my lord, it has not been rejected
Yes,
because
sir.
this application was filed
No, just let us
2020, my lord.
verify. So, copy, admit. No, it has never. It has never. Yes, come to that PW3. Please place if you have got. Mr. Tripathi, have you got the?
Yes, yes.
Yes. PW3 place code.
Yes, my lord. My lord, I know the accused Vodka who belongs to my basti. I know this is Pradeep alias Deepu who addressed me as Didi. I do not know the informant. Occurrence took place on 3rd October 2016 at about 9 p.m. in my house. At that time, myself and Deepu were present in my house. At about 9 p.m., accused entered into my house. By then, Deepu was about to take his dinner. Accused shouted at Deepu that he would assault him, as he has declared him as thief of hen. He suddenly assaulted Deepu by means of a stick at his head. He inflicted about 10 to 15 blows at the head of Deepu by means of that stick. Deepu sustained bleeding injuries at his head and he fell down on the ground. When I tried to intervene, accused threatened me to assault if I made any shout. In fear, I did not intervene. One Chandan has seen the occurrence standing in front of my house and he shouted. Other Basti people.
କୁକୁଡ଼ା ଚୋରି କରୁଥିଲା ବୋଲି କହିଲାଠୁ ବାଡେଇଲା।
This is alleged.
କାରଣ ଇଞ୍ଜୁରୀ କଣ ଅଛି ଆସନ୍ତୁ PM ଡକ୍ଟରଙ୍କର।
PM doctor injury report is there, my lord. That is also quoted in judgment also.
PW8.
ଅଛି ନା? My PW8 statement only.
PW8 ଅଛି ଆମେ ଦେଖୁଛୁ ଯେ। ତିନିଟା stitch left front to parietal one so. Then again ସାତଟା stitch one so. ପୁଣି ଆହୁରି 10ଟା stitch ପୁରା ମାଛି ମୁଣ୍ଡକୁ ମାଟି absence of all the internal organs cause of death is due to coma due to head injury.
Yes, sir.
The background is ठीक अछि Marthan, but the manner in which you have assaulted, number of injuries have been caused and particularly head. You see how many blows were given. Almost ସବୁଗୁଡାକ injury ମୁଣ୍ଡରେ ear, top, nasal bones ଏଗୁଡାକ ସବୁ ଏଇ ଏରିଆରେ ଯାଇଛି। ସେ ଯୋଉ କହୁନି 10-12ଟା ମାରିଛି ବୋଲି ସେଗୁଡା ସବୁ।
Well, the interesting part of it, whether he has the perpetrator of crime, that has not been examined with the trial court properly. Whether the present appellant has committed the crime.
And how do you overcome this evidence of PW3?
Because my lord, PW3 at whose house the victim was taking, the deceased was taking the dinner. And the incident occurred, there was two weapons. And in the weapons, there is no fingerprints. There is no footstep symbols, prints of the accused in the house of the PW3. An interesting part of it, there is one iron rod was available, one stick was available. Both were blasters were available in both the weapons. But interesting, only the stick was seized, and that stick and the iron rod was also seized. But whether bloodstain belongs to the victim, deceased, or whether the bloodstain of any other person or animal, nothing is there.
animal.
କାହାକୁ ମାରିଥିବେ କଣ କୋଉ material ଆଣିଲେ where from they got it? Well, this material is not there.
Eyewitness
Who is
is
saying well,
present. Eyewitness was present with the deceased
Yes,
at that point of time when the occurrence took place,
yes, ma'am.
and he has stated that the assault was by means of a stick.
Yes.
So stick was seized, and the doctor must have given the opinion that with the stick.
No, that is not there. That
no,
is not there.
we do not know that.
My lord, one more thing, that iron rod was also seized, my lord. There was also blood stain.
ହୁଏତ ସେଇ ରକ୍ତ ପଡିଯାଇଥିବ ସେଠି
Two
iron rod
persons
ଟେ
have attacked,
ପଡିଥିବ
two persons have
ତାପରେ
been attacked, one person. Because one witness has
we are not taking of this matter on merit. We are yes, whether there is any whether you are entitled to bail or not, that is
Yes,
to be
ma'am.
seen, because we cannot give any finding even on
Yes,
merit of the case.
that is-
Otherwise, it may have impact on the final
Yes,
hearing
ma'am.
stage.
That is
Okay.
there.
So you are not even in custody for 8 years. You are in custody
7 years,
for
8
7
months,
years, some months.
9 months.
What about the criminal antecedent?
No. That is not.
ଆପଣଙ୍କୁ ସେ କୁକୁଡ଼ା ଚୋରି କହିଲା ଚୋର କହିଲା ବୋଲି ତାକୁ ମାରିଲେ, but the manner in which you assaulted, 10-12ଟା ଖଣ୍ଡେ blow ଖାଲି ମୁଣ୍ଡକୁ ମାରି ଦେଇଛନ୍ତି.
The witness is saying that he intervened. That means apparently his presence is there.
See what that
Natural.
that comes out, my lord. But my only anxiety is that there are so many probabilities. It's not beyond reasonable doubt.
This witness was rated that 10 to 15 blows on the head.
Yes, ma'am.
We just were verifying the PM that whether there is anything to corroborate the evidence of this eyewitness. We found that in fact
That is there,
the manner in which the blows were stated to have been given is corroborated by the, but again we are not giving any finding. So, and this is a matter of 2020. So,
A young boy, 20 years.
what is your age?
20 years. And then when the incident was occurred. And that too, the woman.
So you obtain the instruction about the criminal antecedents.
The CD mile, that is not there.
Let us IN number 55 of 2020, 56 of 2020. This is an application for bail. The London Counsel for the petitioner submitted is in judicial custody since 4/10/2016, and case is based on the evidence of the solitary eyewitness PW3 and the evidence of the doctor bracketary PW8 who conducted post-mortem examination. London Counsel for the state seeks some time to obtain instruction about the criminal antecedent, if any, against the petitioner. Put of this matter will be commencing from 29th of July 2024. Instruction be obtained in the meantime. The other IA, that is for stay of realization of fine, that is allowed. Okay.
Item number 34.
May I please your lordship, Miller? The present appellant convicted for 302 IPC and Miller similarly acquitted from the Miller charge under section 341 and 294. That is the internal bail judgment Miller 29. Now the Miller consideration for bail, that is IA number 1810 of 2021. The appellant inside the custody Miller 18/1/2016, near about 9 months Miller. 18/1/2016.
What is the date of custody you said?
18/1/2016. Miller occurrence took place on 17/1/2016. The date the deceased Miller expired on 21/1/2016. While his treatment was Miller going on at SCB Medical College.
What is the name of the deceased?
Ashok Ojha Miller. And Miller so far eyewitness.
Just a minute. Who is the eyewitness?
PW 5 and 6.
And doctor is?
PW 9. 9 Miller 13 over J. करथिले मिलर कट एसीबी रे पोस्टमार्टम रे
PM करथिले PW 13
13 9 Miller preliminary treatment given as because 307 initially FR Miller 307
PW 5 টা টিকে আনলে
running page Miller
please praise that PW 5
17 71 Miller and PW 5 of course is a minor Miller 16 years age. I know the acute deceased is my father, informant is my mother. Occurrence took place Miller on 17/1/2016 at about 2:30 p.m. in my village road. At the relevant time, myself and one Swagatika, PW6, were learning scooty on the road near the occurrence spot, Miller. My father was standing at the end of the road in order to guide about the learning scooty. While myself and Swagatika were coming towards our father, saw the acute present appellant was abusing my father in obscene language and threatened him to kill as he did not get his outstanding dues. He thereafter gave assault with a wooden thenga to the leg of my father and further gave assault by the said wooden thenga upon his head. 1 Miller upon his head. He sustained bleeding injury due to assault and fell down. Despite our protest, the accused did not listen and went away through paddy field, taking the said wooden thenga. We also read Miller Halla. Then some persons came to the spot. He was shifted to Haripur Medical and then to Kotak for treatment. After 5 days of treatment, my father died. After assault,
same is the evidence of PW6
6 Miller same.
acha
ସେ
come to
କହୁଛନ୍ତି ଆମେ ରାସ୍ତାର ଗୋଟେ ପଟରେ ଥିଲୁ
the evidence of the
30
PW 13 yes
ରନିଂ ପେଜ 89 ମିନିଟ ଅଛି external injury right hip constitution ଏତିକି ବଗି swelling left ଏତିକି ସେ ମିଲର VI 7 confusion of size 6 cm present over right front partial lesion ସେ ଗୋଟିଏ injury ମୁଣ୍ଡରେ ମିଲର ଏଟା 7 ରେ ଅଛି paragraph 2
ନା ଗୋଟେ ଗୋଡରେ ମାରିଥିଲେ ବୋଲି କହିଲା ଦିଟା ମାରିଥିଲେ ଆପଣ କହିଲେ
ସେ କଣ ନାହିଁ
ଗୋଡରେ କିଛି ନାହିଁ ଜୁରି
swelling of left pattern
what is the cause of death here
cause of death is due to cerebral injury sustained
cranial cerebral
ହେଇନି dying declaration
dying declaration
ହେଇ 5 ଦିନ ପରେ
so 8.5 years both the witness PW5 and PW6 they have stated that you have dealt a single blow on the head
yes sorry
no that's not a correct statement you made you see the PW6 evidence PW6 stated
pre-stroke with thenga upon his
on
head.
the head yes 5 has stated that
One.
is why we are asking and seeing that how so many injuries come on the head because
thereafter the accused gave finger blow to the leg of Ashoka for which he sat down for leg nine he sat down on the ground and thereafter accused again 2-3 strokes
କାରଣ ଇଞ୍ଜୁରିରୁ ଜଣା ପଡୁଛି ଯେ ମୁଣ୍ଡରେ 1 ରୁ ଅଧିକା ମାଡ଼ ହେଇଛି ବୋଲି
ପଡିଗଲା
No, that is not been accepted by doctor. It is not possible to ପଡିଯିବା
ଡକ୍ଟର ପାଖରେ ବି ସେ ଲାଠି
No
exam
weapon of offense was produced during my examination. It is not possible for a
ହଁ
person.
no weapon of offense are
So that is
produced
all right,
during
but
my
it is
exam
not possible for a person to sustain such type of injuries if it falls from a height.
ତାପରେ ମୁଣ୍ଡରେ ଯୋଉ ଅଛି ସେ
No,
skin deep
in
1
that
cm
case,
length
you would have brought out at least that even a single blow can cause all these injuries. यदि आपण
1 cm length मिलो
no head रे जो injury गुड़ाक अच्छी आपणकर
ସବୁ ସେଇ right ମିलो partial 5 cm in front 5 injury number मिलो VI5 stitch lacerated wound of size 5 cm present over right parietal region placed 5 in front of right maintenance causing etic right abdomen causing looking reddish brown color etic same
right frontoparietal region रे जो injury गुड़ाक अच्छी 4 5 6 7 एगुड़ाक सबू से पाखापाखि इंजुरीज गुड़ाक राइट साइड रे आउ कंट्यूजन गोटे रोची नंबर 2 रे mastoid process रे सेटा गोटे रोची so these are all on the right side
leg रे किछ इंजुरी नाही
ना leg नाही तो सेत पई पचरा होतले leg रे किछ नाही but
after 5 days मिलो treatment मिलो 17 to 20
you have put a question in the cross examination that he has answered that no, it is not possible if somebody falls from a 10 feet height on a hard surface.
मैं गोटे डिफेंस विटनेस देखुल जे से ब्रिज रु पड़ी गला
For the learned counsel for the petitioner, learned counsel for the state, the learned counsel for the petitioner submit that the petitioner is in judicial custody since 18/1/2016. The occurrence in question took place on 17/1/2016 and the deceased died on 21/1/2016 during course of his treatment, and PW5 and PW6 are the eyewitnesses to the occurrence. Though it is stated by the eyewitnesses that the assault was made by the appellant on the leg of the deceased Ashok Ojha, but the doctor bracketed PW13 who conducted postmortem examination has not noticed any injury on the leg of the deceased. The learning council submits that there are good chances of success in the appeal and balance of convenience is in favor of the petitioner, and therefore the bail application may be favorably considered. Learning counsel for the state, on the other hand, opposed the prayer for bail and placed the evidence of the two eyewitnesses, PWs 5 and 6, and also the evidence of the doctor bracketed PW 13, who has noticed number of injury on the right frontal region of the deceased and opined that the cause of death was due to craniocerebral injuries. After hearing the learned counsel for the respective parties, taking into account the evidence of the eyewitnesses, also the postmortem report finding, we are not inclining to release the petitioner on bail on merit, but taking into account the ratio laid down in the case of Letty versus Swanso and the period of detention in judicial custody, we are inclined to release the petitioner on bail for a period of 3 months. बाकी से जो रिपोर्ट अभी कॉल करो आगुल जो और है ना, and you fix a date of surrender after 3 months, है ना, he has to produce the surrender certificate. Here. And there is another application for stay of realization of fine that is allowed. Huh? Yes.
Item number 35.
Yes, Mr. Jafrullah.
Letter. Yes, in last occasion, my letter. I don't have the copy of the deposition.
Deposition copy.
ମୋ ପାଖରେ ନାହିଁ last occasion I was engaged.
Why didn't you collect from the pen drive? Your
Actually last occasion ମୁଁ वकालतनामा ବି ଫାଇଲ କରିନଥିଲି କୋର୍ଟ କହିଥିଲେ ଯେ ଷ୍ଟେଟ କୋର୍ଟ वकालतनामा ବି
see what is the order passed on the last day. Prayer has been made. Acha, is a prisoner's petition ଆସିଲା ନା?
ଆଜ୍ଞା
ହଁ. ଆଚ୍ଛା, ଷ୍ଟେଟ୍ କାଉନସିଲ ଟୁ ଅବଟେନ୍ ଭି ନାମା ଅଛି।
ଆଜ୍ଞା
ଓକେ, ସେ ଆପଣଙ୍କୁ କୋଉଠୁ ନାଁ ଶୁଣିକିନି ଲେଖିଛନ୍ତି ପ୍ରେୟାର କରିଛନ୍ତି। वकालतनामा ଦେଲେ ତ?
We have already sent letter on 10/7/24.
So produce that V nama so that he can
Yes,
print it
sir.
up and
Next
file
week,
it.
yes.
Okay. And whatever you want, please take it in your pen drive. Okay, the evidence copy or whatever you want. The learned counsel for the state submitted that as per the order dated 1/7/2024, instruction has already been given to the concerned jail superintendent for obtaining the V nama of the appellant. And the matter may be taken up next week. Rakila Vada?
Yes, ma'am.
Next week. The learned counsel for the appellant submitted, Mr. Jafrullah submitted that he may be supplied with the deposition copies of the witnesses in his pen drive. Let the registry supply the same pen drive of so and so. Matter will be taken and be commencing from 27.
Item number 36.
35 barabar, 36.
May I
Item
please, Mr.
36, yes.
The prisoner petition has come in the registry.
Mic tab adjust करो.
Prisoner petition has come in the record.
So have you filed your V nama?
Yes, yes.
Lekon, period the prisoner's petition at flag E, wherein a request has been made for engagement of Mr. B.B. Rautfel and counsel as his advocate. Mr. Rautfel has also filed the V nama, which is accepted. The name of the earlier engaged counsel shall not be reflected in the cause distance process. What do you want?
The appellant is in custody since 12/12/2014.
Just a minute. That is CRLA 266 of 2022. Sanjeev, single sole appellant?
Sole appellant.
Sanjeev Mitra. So what is the custody date?
2014. 9 years, 7 months.
And what is the conviction and what is the sentence?
302 along with other offences, sentence for life, at paragraph 9.
Who is the deceased?
Deceased, Tikanath Kalu. Tikanath Kalu. Kalu.
Date of occurrence?
Occurrence, 8/12/24.
8/12/2014.
Sorry. 14. I'm sorry. 14.
Okay. Eyewitnesses are there?
No, no.
So what are the circumstantial evidence?
Confession before the police and notice of recovery.
What was recovered at your instance?
From my possession, the petitioner's motorcycle and one pen drive was seized.
Motorcycle
and one pen drive. And on 27 recovery, the dead body was recovered at my instance.
Section 394, 397.
Yes. Other offences there.
27 evidence act dead body recovery alla.
Again.
Who?
From a jungle, the nearby the NH.
Let it come tomorrow, Milan. I have wrong file received.
Fine, the file.
No, file that 23 ମସିହାରେ ପଳେଇ ଆସିଛି 22 ଜାଗାରେ।
अच्छा हो काली टेक। अच्छा ये order टा already रखा है गरानी। So you do one thing, you bring it in the supplementary list. बोले supplementary list में। List this अच्छा settle लिख देना पड़े। तापर लिखंतु the Learning Council for the state submitted that the matter may be taken up tomorrow. Out of this matter, तालिका date 23 तारीख ଆଉ ये जो आईएटा ଅଛି stay realization of fine ସେଟା allow कर बेल टा भी खाली रखते हैं stay realization of fine टा allow like that. Yes.
Item number 37.
Item 37, I pray for some one passover, my lord. Picking casually another pass. Apply, my lord.
Item number 38.
May I please, my lord? My lord, conviction under section 302 for life, my lord, and 5,000 fine, my lord.
is JCRLA 108 of 2022. Single appellant?
Yes, my lord.
Okay. So what is the date of custody?
31st March 2016.
No, date of arrest is 19/5/16.
No, my lord, 31st. 31st, my lord.
देखियो ये final form टा ଟିକେ ଦେଖିଲ.
The judgment there is also, my lord.
Just a minute. Let us see.
31st March
Your
2016.
name is ସମରଜାନି.
Yes, ma'am.
ସମରଜାନି ଲେଖା ହେଇଛି ହଁ ଫରୱାର୍ଡିଂ ହଉଛି 1/4/2016 ରେ.
Arrested on 31st and date of occurrence.
Wait. 1/4/2016 you are forwarded to court. Then we want to know that whether at any point of time you are released on bail during trial.
No, my lord, not.
No. Sure. That also let us see.
Let them supply the deposition copy.
No, that you collect your.
3 days, my lord.
How it is.
Days, my lord. It will receive the day.
Yes.
Mr. Pasul, you
Yes,
yes,
yes.
correctly. So whether it will be taken up tomorrow or
Day after tomorrow.
yeah, is perhaps a holiday.
Then
So
Thursday.
all right, you collect it. We are
Yes.
not passing any order. Okay, it is there in the weekly list. So it will be taken up. You will be called on 18th. Okay, after Saturday,
Item number 39.
My lord. My lord, I am on virtual mode, my lord. My lord. Item 39 on back, Mr. Pratik Naik, pray for next week, my lord.
the mention is CRLA number 45 of 23. Mention is made on behalf of Pratik Naik.
My lord.
For adjournment next week. Release this matter on 22nd July 2024.
Obliged.
Yes.
Item number 40.
Please, my lord. Last occasion, my lord also directed to obtain the criminal antecedent of the appellant.
And also the custody certificate.
Custody certificate, yes. He is in custody since
And
my lord.
instruction regarding the conduct of the appellant in jail.
Yes.
Mr. Tripathi.
Kindly taken up Thursday, my lord. I will take it.
Kebe? Thursday.
Guruvar.
From this weekly
Yes.
list it will be.
Yes.
18, 7.
Item number 41.
These are my lords. Lordship has directed for the custody certificate and the
Kebe ka order itla? Acha. Land Council for the state seeks some time to obtain the instruction regarding CA. Then also custody certificate. Official custody since 26/1/2016. कौन हला?
Thursday, my lord.
Thursday.
Obliged.
Yes.
Item number 42.
42, my lord, I'm challenging the conviction given learned session for judgment on 10/11/2020. There are 3 IAs, my lord. 2 IAs are allowed, and that is IA number 4441 and 440. One is for stay of realization of fine and another for delay condone. Appeal was admitted, and 441, which is stay of realization fine, was also allowed. And item IA number 442, which was filed for bail, is pending.
Yes. You want to move today?
My
Okay. CRLA 161 2024. Sole appellant.
sole appellant.
Okay. Honda alias Loknath Pradhan. And what offense he has been found guilty?
That is item 302, 394, 201, and 34 of IPC.
302, 394, 201, 34 IPC. So, what is the allegation? What is the prosecution case?
The date of arrest was on 24/11/2016.
24/1/2016 is the custody date. Okay.
And 31/7/2017 charge sheet was filed.
It's all right. What is the prosecution case?
Prosecution case, my lord, that the sole appellant along with other accused and went to a tea stall on 6/2/2016 to arrange a pickup vehicle and for their transportation of their belonging from Ganja to Digapandi. And accordingly, they once Sunil Reddy was ready to pick up their belongings with the amount of 2,400 by vehicle number OR 07.
What is the name of the deceased?
Sunil Reddy.
Sunil Reddy. Yes. Se vehicle कौन आला तापरे?
Then he agreed to pick up, transport their belongings, and accordingly,
The deceased agreed.
decision.
Yes.
Then then they went the sole appellant along with other appellant. They went with the driver, and about 7 p.m. the relatives of the deceased found the phone of the deceased was got switched off, and they tried to contact, but they found the phone was switched off. And on 7/2/2016 at about 12 noon, the informant, who is prosecution witness, a prosecution witness 2, that the dead body lying over the culvert of Sankha Nuaga Highway. It's lying there.
No, it's a case based on circumstantial evidence.
And all had independent witness. No.
Circumstantial evidence. So that means one is maybe that last scene. You had gone with the deceased in that particular vehicle. Who has stated about the last scene?
That is for last.
PW1 1 3 4 5 6 7 8 9.
Okay, they have stated that.
Yes,
how many persons went in that vehicle?
That is
in which the deceased was the driver.
Yes, madam.
Yes.
Only appellant or any other?
No, along with other, there are
Along with the another person went to Ganja.
No, just let us say one evidence. Let us PW1.
PW1.
So he said after receiving the cash of rupees 2,400, R. Sunil Reddy along with the accused and another person
Yes.
went to Ganja Ganja is a place
Ganja is a
in a
place.
pickup van. Since Sunil Reddy did not return till 9 p.m., so they left and did not return. We thought that why he had not returned. Query made on the next day morning, tried, and he find out and went to Ganja along with Swansu. When he reached at the block, they told her that you go to some. Okay. So last scene is there. Then what else is there?
Last scene only.
Only last scene. And dead body was found where?
Dead body is on under Huma outpost, Sankha Nuaga highway of Sankha Nuaga Culvert.
Achha, near a culvert.
Yes.
By the side of NH.
By the side of NH. Any motive, Mr.
To steal that vehicle, Miller.
So ultimately, that vehicle was recovered from whom?
The tool seizure that PW5 was the parts of the vehicle was seized by PW5 Miller and
No, anything.
They dismantled that vehicle
Okay.
and sold that to the Kabaddi.
Kabaddi wala.
Yes.
But that Kabaddi wala has been examined.
A seizure witness has been
seizure witness that is.
No, Haji stated that it was given to them by the appellant.
No, Miller. No, where it is.
Just a minute. Asking him.
Yes.
So let us say some parts of the vehicle of the deceased was recovered from the Kabaddi wala. Then again you are to link that who has given him to.
That will verify. That is it.
So anything else is there?
No.
You are in custody since 2016 January.
Yes, my lord. 24/11. Just a minute, my lord. 24/11/2016.
What is your good name, madam?
Mrs. S. Das. I'm on record.
Full name is?
Sharda Das.
Sarada.
Yes, ma'am. And DSH, my lord.
Hard Miss Sarada Das, Land Council appearing for the petitioner, Land Council for the state. The Land Council for the petitioner submitted that the petitioner is in judicial custody since 24/1/2016, and as such he has remained in judicial custody for 8.5 years. The occurrence in question took place on 6/2/2016, and it's a case based on circumstantial evidence. And the main circumstance is the last scene, which is deposed to by PW1, 3 and other witnesses. And the deceased was deceased Sunil Reddy, R. Sunil Reddy, was the owner cum driver of the pickup van in which he carried the appellant and another. But he did not return on the date of occurrence, and his dead body was found near a culvert by the side of National Highway on the next day. And though the evidence on record indicates that the parts of the vehicle was seized from a kabaddi wala, a scarf dealer, but there is no evidence on record as to who gave those parts to the said person. and therefore there are good chances of success.
Grateful, man.
Item number 43.
I have filed 4 appeals, my lord. So far as period of detention is concerned, my lord, all are, my lord, about 11 years they have inside custody. My lord, my prayer before your lordship, my lord, in criminal appeal number 479 of 2024, there are 2 women accused, my lord. They were on bail during trial, my lord. And my lord, here is the case, my lord, 5 persons have been killed. And eyewitness is, my lord, only PW 13. And no specific overt have been attributed. 5 persons. 9 live ଦେଇଛନ୍ତି 302149.
No. No instruction this. Short formula, no instruction.
My prayer before your lordship, my lord, let these 2 women accused persons may be released on bail.
In next week, my lord, I will.
Have been taken by DPP.
Yes, ma'am.
My lord, I will say this. Judgment that is, my lord, in paragraph, your lordship will kindly turn to page
Internal page 21. Internal page 21.
page 19, my lord.
Committed
Page
murder.
internal page 21.
Rampil Thapa, Kunu Thapa, Madrasi Thapa.
20, page 20. Internal page 11. 48. My serial number 1. Serial number 1 টা দেখুন তো committed murder by intentionally causing death so on so on so on so on so on.
Let them supply the deposition copy.
ଦେଇଥିଲୁ ପରା ଏଥରକ
ସେଇଟା ତ ଏଇଥର ନୁହେଁ, ଏଟା ଜେଲ୍ କ୍ରିମିନାଲ 20/13 ସ୍ପ୍ଲିଟ୍ ଅଫ୍ ମ୍ୟାଟର ଦେଇଛି।
ଦଉଛି ସାଙ୍ଗେ ସାଙ୍ଗେ। And so far as criminal appeal 479 of 24 is concerned, my lord, no formal admission order was passed. ଆଜ୍ଞା ଆଜ୍ଞା।
Item number 44.
ସେଇଟା ତାହେଲେ ତ ଟାଇମ୍ ଅଲଗା ଜିନିଷ
ତମେ ବାହାର କର।
514 days man. Sierra. My lord.
Yes, ma'am. Yes, ma'am. I will file.
My lord, stay realization fine man. That is 1481. My lord.
Item number 45.
What is wrong? Engage करेगा। लिस्ट करेगा तो हाँ। हम कॉपी दिया नहीं, ऐसे नहीं मांगी दिया ना। इधर पे तो ये वो कैसे देखा?
Appeal memo visa.
तो ना तो से एक आधे पेपर वो खाली मिलेगा। अपॉइंटमेंट
additional session, second additional session, judge will start it.
Miller. Yes, I went to.
The Panda and this Jugal Panda and Devan.
I went from your one.
Passover
Item 19.
Correct.
हाँ.
Option. Item number 37. Passover item.
Which matter?
Item 37.
We'll take up after lunch. What is it?
1935 kହୁଥିଲି appeal against acquittal file ହେଇଛି can it be tagged
This Madam Revatilata Pandana's case. Yes,
Kindly attend next week as
you want adjournment. And you, how many persons face trial?
my lord first my lord were 17 one was acquitted
Just a
16
minute.
against 16
One minute.
ତାପରେ ପୁଣି ଆଉ କେତେ ଲୋକ ବି trial
Wait, just a minute. No, AU judgment re
ଆଜ୍ଞା
we want to see a judgment re total accused संख्या होचंदी 16 जण
16 ଜଣ
right.
ଆଜ୍ଞା
So a जो particular item number 9 टा जो criminal appeal file ହେଇଛି
ଆଜ୍ଞା
ଜଣେ file କରିଛି
ଜଣେ
କୁମାର ବାଗ
ଆଜ୍ଞା
ତ ବାକି ଯୋଉ 16 ଜଣ ଆଉ 15 ଜଣ ସେମାନଙ୍କୁ କଣ
acquittal ହେଇଛି state
they
has
have been
filed-
acquitted.
ଆଜ୍ଞା state
Okay.
has filed an acquittal in this case
What is the number?
number I will give
Everybody has been acquitted.
yes
So if you give the number, then can only we say that
I'll
it
give.
is to be tagged with that.
yes ma'am I will give
Alright.
that's now
Lekhi Jantu, Mr. Patnaik, Land Council, appearing for the informant. Now, informant na company na ko.
informant company
Informant submits that total 16 persons
16
face trial in the court of so and so, out of which 15 persons have been acquitted by the London Trial Court, and the state has preferred so and so se jo number ta debe aji debe to
ଏବେ ଦେ
so and so,
ଆଉ ଗୋଟେ
and the matter may be tagged with that, ହେଲା please this matter along with se jo number ta debe.
ତାପରେ ଆଉ କିଛି ଲୋକ ବି acquitted ହେଇଛନ୍ତି and we have filed
No, it may be in a separate trial.
ଆଜ୍ଞା separate.
ଏଇ trial ର ଯେତିକ ସେ ସବୁ ଆସିବ କାରଣ ସେ trial ରେ it may be that witness number 1 ଆଉ କୋଉ witness ହିସାବରେ examine ହେଇଥିବ
ଆଜ୍ଞା
ଏଇ ଗୋଟାକ ଏତିକି ଆସିବ
ଆଜ୍ଞା
ହେଲା
ଆଜ୍ଞା ଠିକ
yes. Your choice.
Pass over item number 21.
Next.
Item number 27.
Yes.
May I please, your lords?
Yes.
This conviction has been made for an offence, your lordship, under section 376(2). 762I, 376(2)F, 376(2)N IPC, read with section 6 of POCSO Act. And I am in custody, Your Lordship, since 20th March 2016, my lord. The prosecution story is, Your Lordship. The informant is my wife.
Who is the victim?
Victim is my
blue. Two is victim, Miller. And this accused person, accused petitioner,
Father.
appellant is father.
What is the age of the victim?
Age of the victim at the time of deposition 10 years.
What she has stated? PW2.
Yes, Miller.
Live streaming करो.
ना फाइल है
बेल आगु रिजेक्ट है नहीं
ना
देखिए this year. So 3 persons faced trial.
yes my lord
So what happened to the other two? This man is Ramachandra Parida.
Ramachandra Pada is mother-in-law. I have moved for back. 4 person is charge sheeted.
All are in this.
So all are in this subject.
Yes, ma'am.
So this particular I has been filed for only this father-in-law.
Yes.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner is aged about 70 years and is suffering from different age-related ailments. And since it's an appeal of the year 2022, there is no chance of early hearing. And therefore, the bail application may be favorably considered. As per order dated 9/7/2024, we asked the learned counsel for the state to obtain instruction regarding the health condition as well as the treatment details of the petitioner. Today, the learned through the concerned jail superintendent. Today, the learned counsel for the state has produced written instruction received from jail medical officer Circle Jail Chaudhwa, which is dated 4/7/2024, wherein it is mentioned that the petitioner is suffering from pulmonary tuberculosis. Land counsel for the state, however, submitted that the petitioner is the father-in-law of the deceased and he has been implicated in the dying declaration. And it's a case of burning the considering the submission made by the learned counsel for the respective parties, the age of the petitioner, the ailment in which the petitioner is suffering from, and period of detention in judicial custody and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail allowed. এটা ঠিক আছে স্যার যে জেরক্স কপিটা স্যার সেপট ଅଛି ଗୋଟେ ସିଟରେ ଦେଇ ଦେଇଛି ତାର କଥା ପାସବୁକ୍ ମ୍ୟାଟର ହଁ କରିବି ହଁ
Item number 6.
May I please, my lords?
I think you have received that copy of the order dated 10/7/24. Not received. We asked the copy to be handed over to you.
Yeah.
Copy written.
Yeah, free copy for me.
Open the another copy. Ekaishi. Planning Council, both the parties who Koichi.
You also not received.
No.
That means it has not been sent to the jail.
No, he has not received. You give a copy to Mr. Panda also.
After this one.
Leave Mr. Hari, Mr. Sadang is there. You are
You
not.
look like another pattern matter.
No, today we are taking up this matter. This matter is like the other matters which we call for the reports from the about. So we have passed the order. So he is to, but we will continue hearing because the hearing has not commenced. And in the other case, I think that report has already come.
Yes, yes.
You have to just cite some distance. So it can be taken up tomorrow. There is no problem. Because after perusing the report,
Yes, ma'am.
we said that if any decision you want to cite or anything you want
Yes,
to
ma'am.
address, you can
On the
address.
question of death
That is
sentence.
the only I could not only I could not homework could not be done. Aji I got a problem.
No, tomorrow we can take up this matter.
Or your lordship will continue with other matters. Okay.
No, he's to start he has not started the argument. So he's to start today. On merit, he's to start. But as per this, we just passed an order that you call for the.
All right.
The report is supposed to come by 25th. So we have time for that. So, but this hearing is to.
On honor before my lord has directed to. It is further directed all the matters shall reach this court well on or before 2015.
So that will be there.
If that probation report से तार conduct report तार background एगुड़ा सबू आसीबो. See that relates to the sentence part. But merit रे we are commencing the hearing to it.
Before commencement of hearing, my lord, I pray that I have filed a written notice of submissions. Fair trial was not conducted, and 328, 329 CRPC has not been conducted. My lord,
328.
328 in procedure in case of accused being lunatic.
Written note of argument.
What is this?
My lord, I may pardon.
What is the material for that? 328.
That an order sheet shows.
What is that?
I'll come.
Point out those specific order sheet.
I'll kind of have a glance.
You have given one copy.
No, 2 copies indeed.
Watch the portfolio. Watch the portfolio. Like it. And see the time it could be.
Give me. Yes.
Order sheet dated.
अपन legal point आगे कौन raise करचंदी कोहना की कोड लिखचें आगे written note रे कोड
Written note of submissions. My lord, come to submissions.
para
My lord, para C, page 4, para C.
page 4.
My lord. That after commitment of the case of the Court of Sessions, a letter was received by the learned trial court from the Superintendent Sub-Jail, Noyagad, by letter number 324 dated 7/2/2020 for shifting the appellant to Circle Jail Chaudhar for medical treatment of psychiatry, which will be evident from the order sheet dated 11/2/2020. Subsequently, another letter, that is letter number 1517 dated 26/5/2020 was issued by the Superintendent Sub-Jail Noyagad for shifting of the appellant to Circle Jail Chaudhar, Cuttack for temporary confinement and to avail treatment at SC Medical College and Hospital, Cuttack for specialized treatment as the appellant is a psychiatric patient, and by order dated 27/5/2020, the learned trial court permitted the jail authority to shift the appellant to Chaudhar Jail, Cuttack. That it is Hon'Ble Cemetery in the present case charged and framed against the appellant on 4/3/21. And months prior to the framing of charge, it was brought to the notice of the trial court that the appellant is a psychiatric patient. The learned trial court, however, instead of proceeding in terms of section 328 CRPC, proceeded with the trial, which cast doubt as to whether the appellant was.
But what is the documents? Along with that document must come on record. Merely because the jail superintendent says that he is psychiatric patient, he can't be the psychiatrist. 328 parameters certificate. Jail doctor must have given a certificate along with that first, at the very first instance. What is that? Jail doctor is there in every jail or sub-jail. So a certificate must be appended with the letter of the superintendent. What is that? Achieve.
Kindly. Order sheet.
Subsequent
My lord, in the bail petition, a report was called for.
Page 253, my lords. Order dated
11/2/2020, my lord. Or
11/2/2020.
my lord. Serial number 9, my lord.
11 to
9, 2020.
2020.
The case record is put up. On receipt of the
On
letter
receipt of the letter
from the superintendent.
Superintendent S.K. White, letter T so and so, 7/2/2020, for sparing the UTB so and so, for
Temporary shifting
to the circle jail, Kota Chodha, for
medical treatment.
psychiatric
সেটা
treatment, same. ସେଥିରେ ସେଇ ଯୋଉ ଲେଟରଟା ଥିବ ସେଠି କଣ
the medical document, the medical document is filed as a ଲେଖା ହେଇଛି.
Man, I may pardon. My lord's query, page, my lord kindly have glanced to page 255. Order dated 27/5/2020.
ତାପରେ
Report of jail doctor and prescriptions are kept in the record. My lord has gotten.
କୋଉଟା କହୁଛନ୍ତି?
page 255.
255. Order dated 27/5/2020.
Case record. हाँ पढ़िले पुराना.
The case record is put up on. My lord has gotten. The case record is put up on receipt of letter number 1517 dated 26/5/2020 from the office of the Superintendent Subjail Noyagad, wherein the Superintendent Subjail Noyagad has prayed to shift the UTP Nanda alias Niranjan Malik, son of Chandrasekhar Malik, village Kusadeba, PS Vodga, district Noyagad, who is required to be shifted to Circle Jail Cuttack at Chaudhar temporarily for confinement and to avail the treatment at SC Medical College and Hospital Cuttack immediately for admission and specialized treatment as per the advice of the jail medical officer, as the UTP suffering psychiatry along with advice of jail medical officer. A report of jail doctor and prescriptions are kept in the record. So here is the case record and advice of jail medical officer. The permission is allowed. The Superintendent Subjail Noyagad is permitted to shift UTP Kali alias Nanda alias Niranjan Malik to Circle Jail Cuttack at Chaudhar temporarily for confinement to avail the treatment at SC Medical College and Hospital Cuttack for necessary treatment and to back to Subjail Noyagad to face trial on being normal. Issue of the copy Subjail Noyagad and Superintendent Circle Cuttack for influence necessary action.
So what are those documents? अच्छा से accused असेन ही. हाँ? नहीं. Okay, counsel is also there.
ନିରଞ୍ଜନ ମଲ୍ଲିକ
ଆଜ୍ଞା ସାର୍
ସବୁ ଶୁଭୁଛି ଏଇଠୁ?
ଆଜ୍ଞା ସାର୍
Okay, then he was taken to SCB Medical College Hospital.
My lord.
Then what happened?
Then he came to Noyagad.
No.
ତାପରେ ମାନେ 4/3 ଚାର୍ଜ ଥିଲେ ମନା. 4/3/2021. 258 pages.
ତାପରେ ଯୋଉ order sheet ଗୁଡା carefully ଦେଖିଛନ୍ତି ତ? କିଛି UTP so and so is not produced. So and so is not produced from jail so and so. No intimation has been received. UTP is not produced. No intimation has been received.
Court has at no point of time recorded anything.
No, my lord.
Then how can you take it?
But in the after
And the court must feel that he is not capable of having his defense because of the unsoundness of mind. At one point of time, one letter comes from the superintendent, thereafter he is being treated at SCB.
Whether he was taken at all to SCB?
No.
You order on the
ତମର ଚିକିତ୍ସା କୋଉଠି କୋଉଠି ହେଇଥିଲା? କେସ୍ ଚାଲିଥିଲା ବେଳେ ତଳ କୋର୍ଟରେ କୋଉଠି ଚିକିତ୍ସା ହଉଥିଲା?
ଆଜ୍ଞା ବ୍ରହ୍ମପୁର ଏନକେସିସି ମେଡିକାଲରେ 3 ବର୍ଷ ଟ୍ରିଟମେଣ୍ଟ ହେଇଛି।
କେତେ?
3 ବର୍ଷ।
3 ବର୍ଷ, ହଁ।
ଆଜ୍ଞା 2016।
ଆଚ୍ଛା।
2018 ରୁ 18 ଡିସେମ୍ବର 1 ରୁ କଟକ ବଡ ମେଡିକାଲ ଯାଇଥିଲି। ସେଇଠୁ କଣ
କେତେ
ହେଲା
କେତେ କେତେ ଦିନ ହେଲା କଟକ ବଡ ମେଡିକାଲରେ କେତେ ଦିନ ହେଲା?
ସେଇଠି 15 ଦିନ ଖଣ୍ଡେ ରହିଛି ଆଜ୍ଞା। ମୁଁ କେମିତି ଖସିକି ପଳେଇ ଆସିଛି, ମୁଁ କୋମା ହେଇଯାଇଥିଲି ତ।
ଆଉ ନିଜେ ଖସିକି ପଳେଇଗଲ?
ଆଜ୍ଞା ଖସିକି ପଳେଇ ଆସିଛି। ତାପରେ ମୁଁ ଯେତେବେଳେ ସେନ୍ସ ପାଇଛି ଦେଖିଲି ଚୌଦ୍ୱାର ଜେଲରେ ଅଛି 8 ମାସ ପରେ।
ଆଚ୍ଛା। ତାପରେ ଚୌଦ୍ୱାର ଜେଲରେ ଯେତେବେଳେ ଥିଲ ତମ ଦେହ
ତାପରେ
ପା ଭଲ ଥିଲା?
8 ମାସ ପରେ ସେ ସାଇକୋ ସ୍ପେଶାଲିଷ୍ଟ କହିକି
ହଁ
ମୁଁ ଏସବୁ ବିଷୟରେ ଯୋଉ ଚାର୍ଜସିଟ୍ ଟା ଗଲେ, ଚାର୍ଜସିଟ୍ ନୁହଁ ଗୋଟେ ନମ୍ବରଟେ ଗଲା
ହଁ
ଦରଖାସ୍ତ, ସେଇଟା ଦେଖିକି ମୁଁ କହିଲି ଆଜ୍ଞା କେସ୍ ବିଷୟ ମୋର କଣ ହେଇଛି ମୁଁ ଜାଣିନି, ଆଉ ଟିକେ ନୟାଗଡ଼ ମତେ ଚାଲାଣ କରନ୍ତୁ। ତାପରେ ନୟାଗଡ଼ ଆସିଲି। ନୟାଗଡ଼ ପରେ 15 ଦିନ ମୋ ମୁଣ୍ଡ କାମ କଲାନି, ମେଡିସିନ ଦେଇନଥିଲି। ତାପରେ ଫାର୍ମାସିଷ୍ଟ ଫୋନ କରିକି ମେଡିସିନ ମଗେଇବା ପରେ ମୁଁ ମେଣ୍ଟାଲ ଠିକ ହେଲା। ତାପରେ କୋର୍ଟ ଫୋଟ ଗଲି।
ଆଉ ତାପରେ କୋର୍ଟକୁ ଗଲ?
ଆଜ୍ଞା ଆଜି ଯାଏଁ ମେଡିସିନ ଖାଉଛି ଆଜ୍ଞା କଣ୍ଟିନ୍ୟୁ।
ସେ ଯୋଉ କାଗଜ ପତ୍ର ଯାହା ତମର ଥିଲା ଟ୍ରିଟମେଣ୍ଟ ର,
ଆଜ୍ଞା
ସେଗୁଡାକ ତମେ କୋର୍ଟରେ ଦାଖଲ ହେଇଥିଲା?
ଆଜ୍ଞା କୋର୍ଟ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ସାର୍ ଙ୍କୁ ଦିଆ ହେଇଥିଲା ସବୁ ଯାକ ଜେରକ୍ସ କରି। ପଠେଇଛନ୍ତି କି ନାହିଁ କହିପାରିବିନି। ଆଉ
section you are referring to?
329.
329.
But the order sheets, different order sheets are there. My lord, again also, my lord, kindly have glance to page 274.
Order number.
Order number 15/9/2022.
15/9.
My lord.
Order number 9, serial number 14.
Latter
54, my lord. Order. Serial number 54.
54. The case record is my lord has gotten to page 274. The case record is put up today for order of the accused Nanda alias Learned Counsel for the petitioner and learned additional PP are present. In view of the receipt of health condition report of the accused from the Superintendent Sub-Jail Nayagarh and its service on both the counsels, the petition is taken up for hearing. The learned counsel files necessary certificate at the foot of the application stating that there is no other bail application similar to the present one is pending in another court having jurisdiction to entertain same. Hard. The learned counsel appointed by DLSA for accused submitted that the accused petitioner being suffering from unsoundness of mind has committed murder of innocent person in the present case and he is in need of property to end. With this submission, he made prayer for releasing on bail. For contra, the learned additional copy submitted that this is a case under section 302, 307, 323, 324, 325, 326, 458 IPC, and the accused is violent in nature, and there is every possibility of repetition of crime. Hence, he objected to grant him bail and prayed for rejection of his bail application. Peruse the case record. This is a case under section 302, 307, 323, 324, 325, 326, 452 IPC. The record reveals the present accused involved in commission of murder of 2 persons, namely Lochan Sethi and Badan Pradhan, and also brutally assaulted more than 2 other villagers of the locality. The medical report of accused submitted by medical officer Sub-Jail Nayagarh reveals that he is a chronic psychotic patient and taking drugs regularly since last 3 years, and in spite of taking drugs, he is not under full control. Hence, his present health condition is not good. That is the finding of the court on perusal of the medical reports filed by the medical doctor. Considering the nature and graveness, the health condition of accused person, and the existence of every possibility that his release may endanger in life, personal safety of innocent people, I am not inclined to allow, hence the bail person being debarred of merit. Before parting, the court directs the superintendent to provide proper treatment to the accused for his better treatment and for certain other inmates of jail as and when required. Issue precaution to the learning counsel for the accused.
By then the trial had started.
My lord.
My lord.
Before that, my lord, I was glance on, I would question the page 261, madam. Serial number order 43.
UTP is produced before the court today. On being asked, the accused expressed that he has not engaged any advocate to conduct his case. Here, learned counsel C. Hence, learned counsel C. Karthika Naik is appointed as STC for the said UTP. Trial resumed. Learned APP and defense counsel are present. Witness, namely Pratap Kumar Mahat is examined, cross-signed as withdrawal and discharged. No other put to system for evidence. UTP is to be produced before the date fixed. Before engaging counsel on the same day, witnesses are present. Whether police papers were supplied or not to the counsel, we have a reasonable time. Breathing time should be given to the accused.
That is, you are right.
On the very day. On the very day was adjourned. So fair trial is also not conducted.
ତା पहिला ଜେରା କରିବ ସେ ବି ଜେରା କରିଦେଇଛି PW1 କଣ ସେ ଜେରା
Hostile ହେଇଛି, no doubt.
କେମିତି?
Exactly. But
how did you commence a trial in which you are ମାନେ
again in another,
yes.
again, my lord, that happened in order sheet shows that again it was transferred to the Odogan. There another APP associate assistant public prosecutor appointed. Same day again resume. Trial resume witness examined.
Order sheet does not say whether police papers were supplied to the defense counsel or not.
Because this, unless you give sufficient time and an experienced counsel, ତାଙ୍କୁ ଯଦି ବାଧ୍ୟ କରିବେ ହଁ ତମକୁ ମୁଁ କରିଦଉଛି ଜେରା କର କଣ ଇଏ ତ PW1 କୁ ସେ ଯାହା ବି ହଉ ସେ ହୋଷ୍ଟାଇଲ ହେଲେ ବି କିଛି
କିନ୍ତୁ ସେ ଆର ୱିଟନେସ୍ ଟା ଏକ୍ସାମିନ କରିଛନ୍ତି ସେଥିରେ କ୍ରସ୍ ଏକ୍ସାମିନ କରିଛନ୍ତି ସେମ୍ ଡେ ରେ
ଆର ୱିଟନେସ୍ ଟା କୋଉଟା
ସେଟା ମାଇଲର ମୁଁ କହୁଛି that is PS ମାଇଲର
PW 21 PW 21 and 22 order dated 30/5/23.
PW 21 was examined on 30th May 2023.
Same day रे अपन रही same day रे कुछ
देखी ठीक है PW 21 हला 30/5/2023 और PW 22
same day.
अच्छा PW 22 also same day.
Page 284 of the order sheet.
अच्छा PW 21 टा key witness so also on that day I received telephone call when doctor informed staying in the night and immediately along with
Jyoti Prakash Panda, PW 21, page 87. 22 होची medical officer. Injured. Jyoti Prakash Panda injured.
Kindly come to the page 283. 283. Serial number 66.
नहीं पेपर बुक नहीं
नहीं हाँ पेपर बुक माने जो
283 order sheet रहेंगे second copy टा दीजिए.
टू रो
आगे second जो छोटा copy टा order sheet टा दीजिए.
order sheet टा को देंगे
page 283 order number 35/23. Order dated 30/5/23.
So dated 30/5/23 serial number 66 ता आगुर letter न अछि ताठु आगुर आरंभ होइछि while production accuracy
हाँ कौन
Malad. UTP Nanda alias Niranjan Malik is produced in custody. Before that, Malad, while production accused Niranjan Malik alleged to have been produced before this court in empty stomach. He has not been provided with food.
Food put jandi. UTP
Nanda Alice 35 order পড়ছি UTP Nanda Alice Niranjan Malik is produced in custody. Witness Jyotish Prakash Praja is present in person. Witness Dr. Balaram Pradhan is present at the remote point at the premises of Civil Courts Cuttack to depose through VC. Learned Senior Advocate C. Kartika Nayak STC is absent. The case record received on transfer from the Court of Additional District Nayagarh on 3/3/23 for disposal as per law. Learned STC C. Kartika Nayak was engaged by Additional District Nayagarh to conduct the case of UTP as STC in his court. Since he belongs to that station, it is felt that Learned STC is facing much inconvenience to travel from Nayad station to Odoga to conduct the case. On the other hand, his name does not appear in the list of STC empaneled for Odoga station. Considering the above facts, Learned Senior Advocate Sri Ravinarayan Barado is appointed as STC from the panel of Odoga station to conduct the case of the UTP. Office is directed to supply free copy of the police paper through copy session. Odoga to Learned STC forthwith. Put up letter for examination of witness. Letter on the same day, my lord. 30th May 2023. Learned additional PP files Hajira of one witness, namely Jyoti Prakash Panda. He is examined, cross-examined, and discharged as PW. No exhibit are marked by the prosecution through. Further, Learned PP give a proposal in form number 1 to conduct the examination of Dr. Balaram Pradhan in ST case number so and so through video conference in view of Odisha High Court video conference rules.
Order sheet रे side रे देखूनी जे सीए तांको कॉपी दिया ही बोली पुलिस पेपर नले इते ई ऑर्डर रिसीव करथा ना कोन रिसीव दिया है
देखो ना
अच्छा एपटे रिसीव
ଆପଣ ତ କୁହନ୍ତୁ କମ ସେ କମ
କୋଟେ
रिसीव
ନା ନାଇଁ
conducting case
ଏତେ ତା ତଳେ ଅଛି ନା ନାଇଁ ସେକେଣ୍ଡ ଲାଇନ ରେ ସେକେଣ୍ଡ ଇୟର
you are conducting case
Yes,
on
ma'am.
side of government. If you say that everything is not there, what is there? It is there in the record.
which one madam
Receipt PP.
ha PP madam that is the
Right.
again second year no
No.
I am on
Please.
that is there
Yes.
yes
It is there. Conducting on the very day is different. Yes.
same day conducted
same then that was brought to
knowledge. Yeah. Then in further summary, Dr. Balaram Pradhan.
The witness is present to remote point of premises of Silkur Cuttack to be examined at investigation. The matter was brought to the knowledge of the counsel. He raised no objection and given his consent for the examination of witness through video conference proceeding. He has submitted the accused will not prejudice if he in any way if at all the said witness Dr. Balaram Pradhan the MO of the case will be examined through video conference. At both parties, the request made by the learned at form number to examine Dr. through video conferencing proceeding as per video conference rules, High Court is allowed. After consulting both the parties, it is held that video conference proceeding regarding examination of Dr. Balaram Pradhan today, that is on 30/5/2023 at about 12 p.m. Dr. Balaram Pradhan is also directed to attend in person along with proof of identity or an affidavit as per Rule 7 2000. Srimati Itisri Panda, senior stenographer, Distance Odoga has been appointed as the coordinator of the court point. The coordinator of court point is directed to be in contact with the witness and guide him for fulfillment of technical and other requirement for executing of successful hearing through video conferencing. He is also directed to ensure that the recommended requirements set out in Rule 4 are complied with, so that the
Technicality.
so one these two witnesses PW 21 and 22 were examined on a day on which the state defense council was examined. That is one. Another जो ता पूर्वुरु जोटा हितला सेटा केबे डेट टा
PW 1 was examined.
हां सेटा केबे
10
हां
27/10/2021
27/10/21
21 तो
My lord.
ଆଜ୍ଞା 2021
Order number 33.
page
261. Page 261.
21
27/10/21, page 261, my lord. Order number 33, my lord.
page
receive को ठीक है देखिए.
My lord, I may pardon.
Receive को police paper सब पेज में तो.
Niranjan Malik 10 का
तीन करी 10 को
सीन काटे ना के STC.
3 का 10 को
page 261 अच्छा
But on the same day,
PW1 was examined.
my lord.
One examined, was examined, discharge. अच्छा ये जो 30/5/2023 ର order ଟା କୋଉ page ରେ ଅଛି
ଆଜ୍ଞା
30/5/2023 ଯୋଟା ପ୍ଲେସ୍ କରୁଥିଲା ଆଜ୍ଞା
এটা পেজ ম্যাটার 283
283
Order number 66, my lord.
The court missed on the very day, that is on 15/9/2022, while passing the order in bail. Once it has come to his notice, that is the time that he could have sent it for the medical board to
I'm sorry,
to the CDM,
my lord.
because he's also
Medical
coming
board to be decided.
he's also satisfied prima facie that yes, he's violent and it will not be fair on the part of the court to release him for the purpose of this, but he could have been handed over to his family member.
ଯୋଉ ପ୍ରୋଭିଜନ ଟା ପ୍ଲେସ୍ କରୁଛନ୍ତି ଆସିଲା ଆଉଥରେ ପ୍ଲେସ୍ କଲେ 329
329, 330 and
They are
331 also 332.
no 329
All are there.
ଆରମ୍ଭ କଣ
329. If at the trial of any person before a magistrate or a court of sessions, it appears to the magistrate or court that such person is of unsound mind and consequently incapable of making his defense, the magistrate or court shall, in the first instance, by the act of such unsoundness and incapacity, and if the magistrate or court, after considering such medical and other evidence as may be produced before him, or if he is satisfied of the fact, he or it shall record a finding to that effect and shall postpone further proceedings in the case. If during trial the magistrate or court of sessions finds the accused to be unsound mind, he or it shall refer such person to a psychiatric or clinical psychologist for care and treatment, and the psychiatrist or clinical psychologist, as the case may be, shall report to the magistrate or court whether the accused is suffering from unsoundness of mind, provided that if the accused is aggrieved by the information given by the psychiatrist or clinical psychologist, as the case may be, to the magistrate, he may prefer an appeal before the medical board, which shall consist of head of psychiatry unit, the nearest government hospital, and a faculty member in psychiatry in the nearest medical college. If such magistrate or court is informed that the person referred to in subsection 1 is a person of unsound mind, the magistrate or court shall further determine whether unsoundness of mind renders the accused incapable of entering defense, and if the accused is found so incapable, the magistrate or court shall record a finding to that effect and shall examine the record of evidence produced by the prosecution, and after hearing the advocate of the accused but without questioning the accused, if the magistrate or court finds that no prima facie case is made out against the accused, he or it shall, instead of postponing the trial, discharge the accused and deal with him in the manner provided on section 330.
Provided the reporter
Provided that if the magistrate or court finds that a prima facie case is made out against the accused in respect of whom a finding of unsoundness mind is arrived at, he shall postpone the trial for such period as, in the opinion of the psychiatric clinician, is required for the treatment of the accused. If the magistrate or court finds that a prima facie case is made out against the accused and he is incapable of entering defense by reason of mental retardation, he or it shall not hold the trial and order the accused to be dealt with in accordance with section 330. 330. My lord, a release of person of unsound mind pending investigation or trial. Whenever a person is found under section 328 to 239 to be incapable of entering defense by reason of unsoundness of mind or mental retardation, the magistrate or court, as the case may be, shall, whether the case is one in which bail may be taken or not, order release of such person on bail, provided that the accused is suffering from unsound mind or mental retardation, which does not mandate inpatient treatment, and a friend or relative undertakes to obtain regular outpatient psychiatric treatment from the nearest medical facility and to prevent from doing injury to himself or to any other person. If the case is one in which, in the opinion of the magistrate or court, as the case may be, bail cannot be granted, or if an appropriate undertaking is not given, he or it shall order the accused to be kept in such a place where regular psychiatric treatment can be provided, and shall report the action taken to the state government, provided that no order of the detention of the accused in the lunatic system shall be made otherwise than in accordance with such rules as the state government may have made under the mental health. Whenever a person is found under Section 328 or Section 329 to be incapable of entering defense by reason of unsound of mind or mental retardation, the magistrate or court, as the case may be, shall, keeping in view the nature of the act committed and the extent of unsoundness of mind or mental retardation, further determine if the release of the accused can be ordered, provided that if on the basis of medical opinion or opinion of a specialist, the magistrate or court, as the case may be, decide to order discharge of the accused, as provided under Section 328 or Section 329, such release may be ordered if sufficient security is given that the accused shall be prevented from doing injury to himself or to any other person. If the magistrate or court, as the case may be, is of opinion that the discharge of the accused cannot be ordered, the transfer of the accused to a residential facility for persons of unsound mind or mental retardation may be ordered, wherein the accused may be provided care and appropriate education and training.
Read next.
331. A resumption of inquiry or trial. Whenever an inquiry or a trial is postponed under Section 328 or Section 329, the magistrate or court, as the case may be, may at any time after the concerned has ceased to be of concerned mind, resume the inquiry or trial and require the accused to appear or be brought before the such magistrate or court. When the accused has been released under Section 330 and the sureties for his appearance produce him to the officer whom the magistrate or court appoints in this behalf, the certificate of such officer that the accused is capable of making his defense shall be received in evidence. 332. Procedure on accused appearing before magistrate or court. If when the accused appears or is again brought before the magistrate or court, as the case may be, the magistrate or court consider him capable or making his defense, the inquiry or trial shall proceed.
Subsequent. এটা তো আরম্ভ হয়নি সেটা গলায় এটা আরম্ভরে তাকে যোগটা দেওয়া কথা এটা কথা হলো যে the courts whether has recorded she accused to be of unsoundness of mind. Second lawyer କେବେ appoint କରିଛନ୍ତି?
ସେତେବେଳକୁ 20ଟା ସାକ୍ଷୀ already ହେଇଗଲେ ମାନେ PW1 to PW20 ସେ first lawyer କରିଛି ଇଏ 21 ପରଠୁ କରିଛନ୍ତି ଆଉ
27/10/2021.
Then he was a senior. No, on 22/11/2023, there is a certificate that he is not.
24 30/5/23 ସାକ୍ଷୀ ଏକ୍ସାମ୍ ହେଲା
No, 55 ରେ order number 55 ର ତ normal ବୋଲି ଅଛି
और ଖାଲି ନର୍ମାଲ କହିଲେ ହବନି ସାର୍ଟିଫିକେଟ ଦେବ
and normal ଯଦି କୋର୍ଟ ଯଦି ନ କହିବ abnormal ଆପଣ କିଏ କରିବେ ଆପଣ କହିଲେ ବି ହବନି
ନାଇଁ କୋର୍ଟ ଖାଲି ସେମିତି କୋର୍ଟ has to give in finding any certificate or any evidence
କୋର୍ଟ ଫାଇଣ୍ଡିଂ କି ଇଏ ଦବନି କୋର୍ଟ ଏନକ୍ୱାରି କରିବ
କୋର୍ଟ ଇନକ୍ୱାରି କରିକି କହିବେ କୋର୍ଟ ସେମିତି ଫାଇଣ୍ଡିଂ ଦେ court himself finding without any inquiry court cannot give a finding.
No, what has been asked to you that when it was brought to the notice of the trial court for the first time that he was suffering from mental ailment, psychiatric problem, who date re tapare court action ame dekhiwa who date re first time court ko intimate hala who stage re setol thila trial. When you are arguing a point, canvassing a point, keep in mind what the law requires, what the section says. That is very important. Even order sheet गुड़ा का refer करिवे, है ना? कारण court 329 आपण जो पढ़िले ताधुरु जणा पड़ुची जे magistrate पाखरे जेते बळे medical document आसीबो produce हबो एवं magistrate जदि देखिबो जे तारो unsoundness of mind अछि जोथि पई से इनकैपेबल कुछ डिफेंस को अड्यूस करियो ताले से प्रॉपर इंस्ट्रक्शन देई परिबनी ता काउंसिल को जे ए डिफेंस नियो कि एया होची प्रकृति रे घटनाटा एमती हेची कहि परिबनी तेणु सी गोटे डमी भलिया खाली छिड़ा हितबो ता सामने रे ट्रायल टा चलथिबो तारो कथाटा आसी परिबनी तेणु लाइकली टू बी प्रिजुडिस सेइथि पई कोर्ट जदि ए विषय रे कन्विंस हे गला थरे जे ये प्रकृति रे आर मानसिक स्थिति ठीक नाही एवं से डिफेंस ठीक से एड्यूस करि परिबनी तेणु सी कोन करियो कोर्ट पोस्टपोन कर दब अर्थात ट्रायल रे प्रोसीड करि परिबनी
कोर्ट प्रोसीडिंग से बुझी पारुनै
कारण से बुझी पारुनी से इंस्ट्रक्शन देई परिबनी तेणु जदि एई भलिया डॉक्यूमेंट आसीबा सत्वे ट्रायल कोर्ट जदि प्रोसीड करूची ताले there is also requirement on the part of the court to mention in the order sheet that yes these documents are there but I am convinced that in spite of the documents the court this accused is able to follow the proceeding so am tar demeanor se type ro madhya either way re se recording kariya darkar tenu sethi pai केउ को समय रे प्रथमे डॉक्यूमेंट आसी कोर्ट को पहुंचीला से डॉक्यूमेंट रे कोन उल्लेख थिला एवं ता ऊपर कोर्ट कोन ऑर्डर कला आइदर वे रे कोर्ट करिवो कोर्ट जदि कहबो नाही ये बुझी पारुनी डिफेंस प्रोड्यूस करि परिबनी पोस्टपोन करिवो जदि कहजी हां ये डॉक्यूमेंट अछि किंतु मु कन्विंस आर देखे जी then also he also mentioned yes these are the documents but I am convinced that no he is appears to be a sound mind he can adduce the defense he is able to follow the proceeding he can so either way रे order so pass an order ତେଣୁ ସେମିତି କିଛି order pass ହେଇଛି କି
ସେମିତି କିଛି ମାନେ
प्रथम ସେଇଥିପାଇଁ ଆପଣଙ୍କୁ ପଚରା ହଉଛି ଯେ ପ୍ରଥମ ଥର ପାଇଁ accused ର mental ailment ସେ ପୂର୍ବରୁ କଣ ହେଇଯାଇଛି ଜାଣି ଦିଅନ୍ତୁ ଏଠି ଆମେ ट्रायल स्टेज को चली आसଛୁ
ଯିବା 4-3-21 ପୂର୍ବରୁ
ହଁ
4-3-21 ରେ
କାଇଣ୍ଡଲି have class 2 page 253
ସେଇ चार्ज फ्रेम ରୁ ଆପଣ ଧରିକି ଆସନ୍ତୁ चार्ज फ्रेम ରୁ केबे कोन डॉक्यूमेंट प्रोड्यूस ହେଇଛି कोर्ट सामनारे relating to the mental ailment of the accused and what order the court has passed then you have to examine 329 whether it is in consonance with the section 329 CRPC or not ओके एगुडा का आपण राइट ये गोटे पार्ट आपण जोटा कहले ना सेई दिन अक्यूज्ड दिया हला सेई दिन ताको पुलिस पेपर हला सेई दिन ताको आला क्रॉस एग्जामिन करे दैट इज वन पार्ट but the other part which is that whether the court at all should have proceeded with the trial unless he is sure that yes the accused is of sound mind the accused can is capable of making defense that means he can impart necessary instruction to his counsel ହେଲା ତେଣୁ he can say something to his counsel counsel ପଚାରିବ ନା state defense counsel ସେମାନେ ପଚାରିବେ ନିଶ୍ଚୟ ଯେ ଘଟଣାଟା କେମିତି ହେଇଥିଲା ଏ ସାକ୍ଷୀ କାହିଁ ତମ ବିରୁଦ୍ଧରେ କହୁଛି କି କଣ କହିବାକୁ ଯାଉଛି ଏ ସାକ୍ଷୀର ଜମାନବନ୍ଦୀ ହଉଛି ଏହା ପୋଲିସ ପାଖରେ ତମେ କଣ କହିବାକୁ ଚାହୁଁଛ ଏହା ବିଷୟରେ ଏଗୁଡାକ ପଚାରିବ ସେ ଆନ୍ସର ଦବ କେତେବେଳେ ଯେତେବେଳେ ଗୋଟେ ସୁସ୍ଥ ମସ୍ତିଷ୍କ ହବ ସିଏ ଯଦି ନିଜେ ପାଗଳା ଭଳିଆ ହଉଥିବ ସେ କଣ ଆନ୍ସର ଦବ ହେଲା ତେଣୁ ସେଥିପାଇଁ ସେଇ କ୍ଷେତ୍ରରେ କୋର୍ଟ ର ଯଦି କନଭିନ୍ସ ହେଲା ସେ ତାକୁ ସେ स्टेज रे ये कर दबो चळीबनी आगु कारण 84 is something different 84 टा कहला जते बेले at the time of occurrence धरो at the time of occurrence मध्य किछि लोकटार सुस्त इ अछि but again by passage of time घटना पर ट्रायल आरंभ होला तार ए टाइप रो स्थिति आसिला एवं से ये रे रिपोर्ट आसिला जेलु आसिला बा ये हला कि एडवोकेट मध्य पॉइंट आउट करले जे तार अवस्था को डिमेनियर मार्क कला एक कला एवं कन्विंस हला रे लोकडा सुस्थ मस्तिष्क रे नाही ये प्रॉपर इंस्ट्रक्शन देई पर नथिबो सेठी कोर्ट रो ड्यूटी टा कोन हां से कोर्ट रो ड्यूटी ना एडी वेरी इलाबोरेटली डील कराई छी 329 ऑनवर्ड से कोन करिवो केमती ताकू ये करिवो पुनी साउंड माइंड आसी गला परे केमती रिज्यूम करिवो ए सब जिंसो ये तापरे कोठी ताकू डिस्चार्ज करिवो ए सब जिंसो मध्ये होई सो व्हेन यू आर advancing a point you must not only see the section but also carefully study the order sheet and simultaneously those documents basing on which that order sheet has been passed order has been passed ताले तीनटा जको आपण जदी कोऑर्डिनेट करिवे ताले आपण फ्लॉ टा जानि परिबे हैं ଏଇଟା ଗୋଟେ ପଏଣ୍ଟ ଆପଣ କହିଲେ we have taken note of it.
But that should be a failure of justice.
ହଁ
Non-compliance of 329 is a failure of justice, miscarriage of justice. In that case, the matter will go to the root of the case. Non-compliance of police paper and conducting the case is not very fatal in that way. But non-compliance of 329 is fatal. That is a miscarriage of justice. So that
For
we have to-
example, let us say ଯେ ଆପଣଙ୍କର ଯୋଉ ପ୍ରଥମ ୱିଟନେସ୍ ଟାକୁ ଏକ୍ସାମିନ ହେଲା ସିଏ ଗୋଟେ ଠିକ ଅଛି ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ପୋଲିସ ପେପର କଲା ସିଏ କିଛି ପଚାରିଲାନି ଡିକ୍ଲାଇନ କଲା but that witness he has pointed out that witness has not supported the
Non-hostile.
ତେଣୁ it cannot be said
Yes.
that he has prejudiced to
Yes.
that extent ତାପରେ ଯୋଉ ଡେଟ୍ ପଡିଛି ତା ପାଖରେ ପୋଲିସ ପେପର ଅଛି ସିଏ ତାର ଜେରା କଲା ହେଲା again 21 and 22 they have stated something so but ଏଇଟା ଏଇ ଯୋଉ ଜିନିଷଟା as has been right it goes to the very root of the matter ଗୋଟେ ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲ ସେ ନିଜେ ଇଏ କରୁନି ଷ୍ଟେଟ୍ ଡିଫେନ୍ସ କାଉନସିଲ ସେ ଟୋଟାଲ କିଛି ଜାଣିନଥିବ ତ ଯାହା ବି କେସ୍ ବିଷୟରେ ଜାଣିବ ସେ unless he got the scope and opportunity to interact with the accused number one and unless the accused is in such a condition that he can say something which would help to make out a defense then it cannot be said that the trial is fair right from trial fair ହବାକୁ ହେଲେ ତାକୁ proper material ତାଙ୍କୁ ଦବାକୁ ପଡିବ so that ସେ case ଟାକୁ ultimately case may end in conviction case may be acquittal that's a different matter but fair trial ର ଯୋଉ concept ହଉଛି ସେଠି advocate ହଁ senior advocate କୁ ତମେ ଦବ but senior advocate କୁ ଦେଲେ କଣ ଖାଲି senior advocate ହେଇଗଲେ material ପଳେଇ ଆସିବ କି senior advocate if he is engaged in a state as a state defense counsel unless he gets material from the that accused how can he defend the case ଯାହା ପଡିବ ସେଇ ପେପର ପଢିକିନି ସେ ଜେରା କରିବ କିନ୍ତୁ ଘଟଣାର ରୁଟ୍ କୁ ଯିବାକୁ ହେଲେ ତାକୁ କିଛି ଆସିଷ୍ଟାନ୍ସ ଦରକାର କାହାର accused ର ଦରକାର ବା ତା ଫ୍ୟାମିଲି ମେମ୍ବର ସେ ବିଷୟରେ କେସ୍ ବିଷୟରେ ସେ ପଚାରିବେ ଏଠି ତ accused ହିଁ ଯଦି ଆସିଲା ସୁସ୍ଥ ମସ୍ତିଷ୍କ ନୁହେଁ ହଁ ସି ଯଦି ଏଇ ଟାଇପ ର ତାହେଲେ ସି କଣ ଫିଡବ୍ୟାକ ଦେଇପାରୁଥିବ ତା କେସ୍ ବିଷୟରେ ତେଣୁ ରିଏଲିଟିଟା ଆସିପାରିବନି ବା ଯୋଉ ଯୋଉ ଜିନିଷ ତାର ଫେଭରରେ ଆଣିବା କଥା ସେ ଜିନିଷଟା ଆସିପାରିବନି କେସରେ ତେଣୁ ଆପଣ ଯୋଉ ପଏଣ୍ଟଟା ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ଇଟ୍ସ ଏ ଗୁଡ୍ ପଏଣ୍ଟ ବଟ୍ you are to go meticulously
because again in order number 51 you can see the court has asked for the mental status of the accused
time to time court ପାଖରେ document produce ହଉଛି court mental ଇଏ କରୁଛନ୍ତି ଏବଂ bail order ମଧ୍ୟ finding ଦଉଛନ୍ତି ଯୋଉଟା କି ଆପଣ place କଲେ ମଧ୍ୟ ଯେ ସେଇ type ର mental condition ହେଇଛି it's all right ହଁ mental condition ପାଇଁ bail ଅଲଗା କଥା ତମେ ଦେଲ ନଦେଲ that's a matter
but what should have been the role of the court on having come to know that this is the mental status whether the rejection of bail is enough or the court should have given other direction also so that is also a point to be seen you see order number 51 witness and such and such are marks examination the declined issue summon to the other CS witness fixing the case accused is to be produced on the date fixed put up on etiki ସେଇଥିରେ ଦିଆହେଲା letter record again put up to pursue the health status to peruse the health status report submitted by the superintendent of sub-jail Nayagarh on 30/8/22 it is seen that the said report is not the health status report of the UTP Nonda alias Niranjan Malik and the said report one of the
Female UTP of the
female
said
UTP ଜଣଙ୍କର said jail copy of the said report served on additional PP. The additional PP files a memo stating that there is the said report need not be accepted. Hence, for the
bail application file था ताकू नहीं केटा मगा ही जाता then bail hearing ताबे पुणे आउते असला then order pass
order pass ला तो ये जो order pass ला वो
I'll kindly have a glance on the next order matter 276 55 here
55 UTP is produced in custody no PW that is file
but this is file
the accused is normal ମୁଁ କହିଲି ବାସଟା ପଢିଲି ଆପଣ
ଏଇଟା ତ complete
and hearing
ସେଥିପାଇଁ ତ ଆଗକୁ ନେଲେ
proper
ତେଣୁ କି ସେ ଆଗକୁ ନେଲେ
ଆଜ୍ଞା
But was there anything to be done by the court on 15/9/20?
Exactly. To taking an inquiry on
That
that.
is very important. Whether the order of the court rejecting that, but having a opinion, whether it is sufficient or not. Because subsequently he is found to be normal as per the certificate.
But the order
I think
dated in the bail order, my lord.
there is no is there any specific order which indicates that even though the reports has come that he is a psychiatric patient, is so and so is not, had the court recorded anywhere that yes, this record I have perused, but after looking at the or after having interaction with this so and so, I am convinced that the accused is capable of making the defense, so I am proceeding with the trial.
No orders. Verify করছি না, sir.
ନାଇଁ ସେଇଟା ଦେଖିବା ଆଗ, ସେଇଟା ଦେଖିବେ କାରଣ ଇନକ୍ୟାପେବୁଲ ଅଫ ଡିଫେନ୍ସ ହେଲେ ଆର୍ଜନ କରିବ, କ୍ୟାପାବୁଲ ଅଫ ଡିଫେନ୍ସ ଦେଇଦେଲେ ପ୍ରୋସିଡ କରିବ।
Proceed.
ତେଣୁ ଏଠି ସେ କୋର୍ଟ ପ୍ରୋସିଡ କରିଛି। Once you with these documents, if you are proceeding, then you are required to mention this, that yes, these documents have come, that he is a psychiatric patient at the present, but in spite of that I am convinced because after seeing all
So the
these things.
kind of report that has been produced from the side of the accused by the sub-jailer or the doctor, that is very important. Right? If at any point of time any such certificate is there that he is not in a position to understand, then court has a role. Absolutely.
And
Court could not
what he says that he was there in Barampur at mental hospital for years together. Again he came to Cuttack. He was treated there for 15 days. He escaped. Then he was caught hold of somehow or other in Chaudhar area. Then perhaps he recapitulated or something like that. May send me to Nayagarh. Then he came to Nayagarh and then the trial proceeded. So ଏଠି ସେଇଥିପାଇଁ ଟ୍ରାଏଲ କୋର୍ଟ ରେକର୍ଡ କରୁଛନ୍ତି ଯେ ତାର କଣ where abouts ମାନେ ଜଣା ନାହିଁ, ସେ ନଟ୍ ପ୍ରଡ୍ୟୁସ୍ଡ ହେଇକି ଚାଲିଛି, କିନ୍ତୁ ସେତେବେଳେ ଆକ୍ଚୁଆଲି ସିଏ ଯୋଉ ପଠେଇ ଦେଇଛନ୍ତି ସେତେବେଳକୁ ସିଏ ଫସି ଯାଇଛି ଜେଲ। ସେ ଯାହାଟା କହୁଛି।
ସେ ଏସସିବି କି ଆସିଥିଲା, ଏସସିବି ରୁ ପଳେଇଲା।
And in that case, no, SCB ରୁ just in that case the report of the authority is also very important. Is it because of his unsoundness of mind that he escaped, or he escaped deliberately? All these important. These documents are very important. When he was got hold of and again brought to the jail, what was the report?
And at least those reports of the SCB Medical College, the treatment paper,
yes,
ସେଇଗୁଡାକ ମଧ୍ୟ ଆଣିବାର ଥିଲା। ଏଇଟା ମାନେ କୋର୍ଟ କୁ ପୁରା ଏକଦମ ଆପଣ ଡାର୍କନେସ ରେ ରଖିଦେଲେ। ଟ୍ରାଏଲ କୋର୍ଟ ସାମ୍ନାରେ ମ୍ୟାଟେରିଆଲ ଆସିଲାନି ଯେ ତାକୁ କୋର୍ଟର ଟ୍ରାଏଲ ପରମିଶନ ନେଇକି ଗଲେ ଏସସିବି ରେ ଟ୍ରିଟମେଣ୍ଟ ହେଲା ବେଳେ ଏ ଲୋକଟା ପଳେଇ ଯାଇଛି 15 ଦିନ ପରେ, ଯାହାଟା ସେ କହୁଛି ଯଦି ସେ ହେଇଥିବ ଠିକ ସେ, ତାହେଲେ ଏଇଟାକୁ ଟ୍ରାଏଲ କୋର୍ଟର ନଜରକୁ ଆଣିବାର ଥିଲା ନା ନାହିଁ। ଟ୍ରାଏଲ କୋର୍ଟରେ ଚାଲିଛି ମାନେ ଗୋଟେ ପରେ ଗୋଟେ ଅର୍ଡର ସିଟ୍ ପାସ୍ ହେଇ ଚାଲିଛି, ନଟ୍ ପ୍ରଡ୍ୟୁସ୍ଡ, ଇଏ
then produced,
ଦେନ୍ ହଠାତ୍ ଗୋଟେ ପ୍ରଡ୍ୟୁସ ହେଲା।
I may pardon, all the order sheets are with me. I have taken on pen drive. But I have already taken on pen drive. From the pen drive, but the documents are not are with me.
No, you can take it. There is no.
To go for it.
What? ପ୍ରତ୍ୟେକ ଡକ୍ୟୁମେଣ୍ଟ କୁ ଆପଣ ଯିବାକୁ ପଡିବ।
And you are amicus curiae. You are not lawyer, private lawyer.
You are to assist us. କୋର୍ଟରେ ଯେତିକ ମେଡିକାଲ ଡକ୍ୟୁମେଣ୍ଟ ଅଛି, you can take it, study those documents, there is no problem.
You can call for the document if at all.
ଆଉ ତାପରେ ଏଇ ଯୋଉ ଇଏର ମଧ୍ୟ ଆପଣ ଦେଖିବେ ସାଇଟେସନ୍ସ ରେ ଏଇ ପଏଣ୍ଟ ରେ ବହୁତ ଡିସନ୍ସ ଅଛି।
ମୁଁ ଗୋଟେ ଆନେକ୍ସ କରିଛି 72 ସୁପ୍ରିମ କୋର୍ଟ।
ଏଠି
ଟ୍ରାଏଲ ଉପରେ ଗୋଟେ ଦେଇଛି।
unless and until ଏଇ ଲାଇଟ ରେ ଡିସନ୍ ଅଛି, unless and until in spite of receipt of the document, the court is convinced that the accused is of sound mind. His condition is such that he can able to or capable of making defense. ए लाइट रे जदि कोर्ट कन्विंस न हबो बा किसी नोट न करिवो, सेही circumstance रे जदि trial proceed करिवो, this trial would not be in consonance with law, it is to be vitiated. से finding reach करिवो जोठी जो source रो accused material आणु jail source रो आणु बा जोठी हो ताकू जदि source रू आसिला जे is a psychiatric patient से 84 is totally different कारण सेते बेले तमे घटना बेले तमे इनसेन घटना बेले जदि इनसेन नथिबो परे तमे डेवलप कला दैट इज कैन मते 84 रो बेनिफिट ता दिया दैट्स नॉट द थिंग बट
exception 84 is an exception here it is a procedural irregular in 328.29 this is a procedural irregularity and that is an exception 84
But some finding the evidence of the IO that the people control the one mental person has caused the incident. What is
so
that?
people may say anything for all purposes we have to go by record on soundness of mind is the satisfaction of the court that the person before him is not capable of giving a rational answer or have the capacity to understand the proceeding of the court. If he is not in a position to understand the proceeding of the court, the entire proceeding is of no use. So there are procedures. 329, 330, if he is found to be with the order of the documents, he will be given in the hand of his family members who will undertake to do certain things. It is there in 329, 330. How the family members will conduct. So all these things. So these orders are very important. Individually you have to go. And as amicus query, you have every right to call for the documents from wherever you want. Yeah. Upon your good name, sir, advocate. Subhu
Sir,
nahi.
kindly
Simply unmute it. Upon na. How to agu ko asantu? हाँ साहू you do one thing. ଆପଣ ତା ପାଖରେ କିଛି ମେଡିକାଲ ପେପର ଅଛି କି ନାହିଁ ଏଇ ତାର ଟ୍ରିଟମେଣ୍ଟ ସମ୍ବନ୍ଧରେ କୋର୍ଟରେ ସେ କଣ ଦାଖଲ କରିଥିଲେ ବର୍ତ୍ତମାନ ତାଙ୍କ ପାଖରେ ଅଛି କି ନାହିଁ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ପାଖରେ କଣ ଅଛି ତାଙ୍କ ଟ୍ରିଟମେଣ୍ଟ ସମ୍ବନ୍ଧୀୟ ଯାହା ସବୁ କାଗଜାତ ଥିଲା ସେଗୁଡାକ ସବୁ କୋର୍ଟରେ ଦାଖଲ ହେଇଥିଲା କି ନାହିଁ ଯଦି ଦାଖଲ ହେଇଥିଲା ସେଗୁଡାକର କପି ଅଛି କି ନାହିଁ ଏସବୁ ଜିନିଷ ଆପଣ ଟିକେ ବିବରଣୀ କରିବେ ଏବଂ ଏଇଠି ଯିଏ ଆମର ଆମିକସ୍ କ୍ୟୁରି ଅଛନ୍ତି ମିଷ୍ଟର ପଣ୍ଡା ତାଙ୍କୁ ଆପଣ ଯୋଗାଯୋଗ କରି ସେଗୁଡା ସବୁ ଦେବେ ଠିକ ଅଛି ତା ସହିତ ଯୋଗାଯୋଗ କରନ୍ତୁ ନିରଞ୍ଜନକୁ ପଚାରନ୍ତୁ ତା ଘର ଲୋକକୁ ପଚାରନ୍ତୁ ଏବଂ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ମଧ୍ୟ ସେ ବିଷୟରେ କିଛି କହିବେ ଠିକ ଅଛି ଏବଂ କୋର୍ଟରେ ପ୍ରୋସିଡିଂ ହେଲା ବେଳକୁ ଦିଆ ହେଇଥିଲା କୋଉଟା ଦିଆ ହେଇ ନଥିଲା ଏସବୁ ଜିନିଷକୁ ଆପଣ ତର୍ଜମା କରିକି ଡକୁମେଣ୍ଟ ଗୁଡାକ ପ୍ରପରଲି ରଖିକିରି ଆମର ସେ ଯୋଉ କହୁଥିଲା ବ୍ରହ୍ମପୁରରେ ବି କେତେ ବର୍ଷ ତା ଟ୍ରିଟମେଣ୍ଟ ହେଇଛି
ମୁଁ ତାକୁ ପଚାରୁଥିଲି ଯେ ସେ ମୋ ପାଖରେ କିଛି ଡକୁମେଣ୍ଟ ନାହିଁ ମୁଁ ସବୁ ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ଦେଇ ଦେଇଛି
ତାହେଲେ ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ଯୋଗାଯୋଗ କରନ୍ତୁ କାହିଁକିନା ସେ ଜେଲ ବହୁତ ଥର ଯାଇଛି ଟ୍ରିଟମେଣ୍ଟ ପାଇଁ ତ ଜେଲର ଟ୍ରିଟମେଣ୍ଟ ପେପର ନିଶ୍ଚିତ ଭାବରେ ସବୁ ଥିବ ଠିକ ଅଛି ଆପଣ ଯୋଗାଯୋଗ କରିକି ମିଷ୍ଟର ପଣ୍ଡାଙ୍କ ସହିତ ଯୋଗାଯୋଗ କରିକି ଡକୁମେଣ୍ଟଟା କୋର୍ଟରେ ଯାହା ଯାହା ଦାଖଲ ହେଇଥିବ ବିଶେଷ କରି ଯୋଉ ଟ୍ରିଟମେଣ୍ଟ ପେପର ତାର କୋର୍ଟରେ ଦାଖଲ ହେଇଥିବ ସେଗୁଡାକ ବି ଦେଖିବେ
ନୟାଗଡ଼ କୋର୍ଟ ତ ଏଇଟା ବ୍ରହ୍ମପୁର ଜେଲ
ଆଜ୍ଞା
ମୁଁ ସାର୍ ବ୍ରହ୍ମପୁର ଜେଲରେ ସେ ରହୁଛି
ଓ ବ୍ରହ୍ମପୁର ଜେଲରେ ରହୁଛି ଆପଣ ସୁପରିଟେଣ୍ଡେଣ୍ଟଙ୍କ ମାଧ୍ୟମରେ ସେ ଆର ଜେଲରୁ ମଗେଇବେ କୋଉଠୁ ଓଡଗାଁ ଆଉ ନୟାଗଡ଼ରୁ ହଁ
ଓଡଗାଁ ନୟାଗଡ଼ ଚୌଦ୍ୱାର
ଠିକ ଅଛି ଓଡଗାଁ ନୟାଗଡ଼ ଚୌଦ୍ୱାରରୁ
ଓଡଗାଁରେ ଆଜ୍ଞା ଜେଲ ନାହିଁ ଓଡଗାଁରେ ଜେଲ ନାହିଁ ନୟାଗଡ଼ ଆଉ ଚୌଦ୍ୱାର
ସବୁ ଜେଲ ଯୋଉ
ଓଡଗାଁରେ ନାହିଁ
ନୟାଗଡ଼ ଆଉ ଚୌଦ୍ୱାର
ନୟାଗଡ଼ ଆଉ ଚୌଦ୍ୱାର
ଠିକ ଅଛି ସେତିକି ତାକୁ ଆପଣ କରିକିରି ଆପଣଙ୍କ ଇଏଟାକୁ ତାକୁ ସେ ଯାହା କହିପାରିବ ନହେଲେ ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ଆପଣ ପଚାରିକି ତାର ନଥି କରିକିରି ପଣ୍ଡାଙ୍କ ସାଙ୍ଗରେ ଯୋଗାଯୋଗ କରି ଆପଣ ସେଟା ପେପର ବାହାର କରିବେ ହଁ ଆମେ ଗୋଟେ ଅର୍ଡରଟେ ଆମେ କରୁଛୁ ସେଇ ଲାଇନରେ, ଠିକ ଅଛି, so that you will get a handle to proceed with this matter. All right.
Yeah. Yes. So basically, this is the task which you are to minutely go through.
Madam.
We'll pass that order that
Madam.
he has to call for, and
Madam.
as my esteemed brother
On the
said,
basis of presumption.
Madam.
on the
Madam.
basis of this. ଆଜି ଆପଣ କୋଉ କ୍ଲାସ୍
ସି ଆପଣ ରିଟିନ୍ ନୋଟ୍ ଅଫ୍ ଆର୍ଗୁମେଣ୍ଟ
Written notes.
ଏଇ ଦିଟାକୁ ଯୋଉ ବେସ୍ କରିଛି
Para C ଆଜ୍ଞା, para C D F.
CT plus
C ରୁ ଆରମ୍ଭ ହେଇଛି G ଯାଏ।
261 ରେ ଗୋଟେ 283 ଆଉ ସେ ଯୋଉ ପେଲ୍ ଅର୍ଡର ତ
H ରେ ଆଜ୍ଞା ସେ ଆର କଥା ଗୋଟେ ବି ଲେଖିଛି। Same day.
ଗୋଟେ ଅର୍ଡର ଯୋଉ ଅର୍ଡର ଆପଣ ଭାବୁଛନ୍ତି ଯୋଉ ମେଡିକାଲ ଇଏ ଅଛି, ଆପଣ ଜଷ୍ଟ ଗୋଟେ ସ୍ଲିପ ରେ ଦେଇ ଦିଅନ୍ତୁ ଅର୍ଡର ସିଟ୍ ର ଏଇ ଅର୍ଡର ଖାଲି ଏତିକି ଦିଅନ୍ତୁ, ମାନେ ମେଡିକାଲ ରିଲେଟେଡ ଇଏରେ ଟ୍ରାଏଲ ଆରମ୍ଭ ହବାଠୁ ଇଏ ପର୍ଯ୍ୟନ୍ତ ହେଲା, ସେ ଦିଟା ଛାଡି ଦିଅନ୍ତୁ, ସେ ଦିଟା ପଏଣ୍ଟ ଆପଣ ସେଇଟା ଗୋଟେ ସେପାରେଟ ପଏଣ୍ଟ। वी आर हार्पिंग ऑन जो मेडिकल डॉक्यूमेंट्स आउ तार ये खाली लिखि दियंतु ऑर्डर नंबर एति डेट एति सेति की जोडा को 4-5टा की 6टा ऑर्डर इमीडिएटली यू पास ऑन सो दैट ऑर्डर विल बी फाइनलाइज हला
ट्रायल केबे होला
4-3-21
ଆଜ୍ଞା
4-3-21 charge framing.
From the date of framing of charge, the trial has started. After that only you have to take.
जो दिनठू चार्ज फ्रेम ହେଇଛି ସେଇ ଦିନଠୁ ଆରମ୍ଭ କରିକିନି ଅର୍ଡର ସିଟ୍ ରେ କଣ ଅଛି ଯୋଉଟା କି ରେଲେଭେଣ୍ଟ ଫର ଦିସ୍ ମେଣ୍ଟାଲ ଅନସାଉଣ୍ଡନେସ୍ ବା ଯାହା ହଉ ତାକୁ ଆପଣ ଖାଲି ସେତିକି ଅର୍ଡର ଗୁଡା ଟିପିବେନି, ଖାଲି ଅର୍ଡର ନମ୍ବର ଏତିକି
ଡେଟେଡ
ବାସ୍
ଆଜ୍ଞା
କରିକିନି ଇମିଡିଏଟଲି ପାସ୍ ଅନ୍
ଆଜ୍ଞା
ହେଲା।
ଆଜ୍ଞା
27-10 witness started appeal 1 first.
ଆପଣ ଟିକେ ଦେଖିଦେବେ, କ୍ରସ୍ ଚେକ୍ କରିଦେବେ, ଯୋଉଟା ରେଲେଭେଣ୍ଟ ହବ ଦେଇଦେବେ ଆଉ ହେଲା। ସୋ
ଆପଣ ଦେଖିବେ ଆପଣ ସାଇଡ
ମୁଁ ସମସ୍ତ ଆମେ ଦେଖି
ଏଟା ଗୋଟେ ଯେହେତୁ ଆମାଇକସ୍ କ୍ୟୁରି ଅଛି, ଡୋଣ୍ଟ ଥିଙ୍କ ଇଟ୍ दैट you are for a so you are to assist us to arrive at the right conclusion.
The position of law, the cases, everything. And Mr. Das will take care of the orders which is in favor of the court. So that it will be easier for us to take.
It will keep some other time.
Yes.
It will be kept, but you give it immediately.
Madam, obliged.